For delivery of judgment, item 1 WPC 8106/19 Niva Shukla Boidya versus Union of India.
In this case, we are remanding the matter back for a fresh decision, allowing you the opportunity to contest the proceedings. You are required to appear within 30 days from the date of the order. On 31st day, this order will lapse and the opinion of the tribunal would revive.
Deeply obliged.
I think 57 that meta your loss hard is only fixed for 5 minutes. Then it will be taken up at 2 that second is only repairing or reconstruction. The second appeal matter.
57.
Then will be taken up 2. I can inform that also.
Yeah, please give me Lordship. Item number 39, Lordship. It may kindly be listed after 3 weeks, Lordship. With the consent of the other side, I would like to mention it, Lordship.
After 3 weeks.
3 weeks, Lordship.
Okay. Here, Agarwala, the counsel for the petitioner, with consent for the counsel for the other side. Here for adjournment, there is allowed list after 2 weeks.
Much obliged.
Very please, your lordship. With the consent of the other side, I'd like to mention item number 24. Your lordship may not like to take up the matter of life. I am for the petitioner, madam.
24.
24. Perhaps your lordship appeared as a counsel earlier during the trial proceedings.
24. Also, as a representative, this before any other bench without me.
Please, your lordship. Lordship, I beg to mention one item for listing CRP 271 of 2.
Listing, please give it to the courtmaster. You have to make some adjustments you may not get on the day you are seeking. All praise for listing, give it to the courtmaster.
Okay.
May I please, your lordship? Your lordship, I'm for the petitioner in item number 16. We have filed the additional affidavit. Today morning itself, it may be called for your lordship.
Yes, I wish to mention item number 23, Lordship. This matter, we need some instruction from our client, Lordship. Can we?
That has become infectious.
No, Lordship. We need some instruction from our client.
Instructions.
That's consent is taken from the other side also. I'm for the respondent number 18, 8, Lordship.
Also, the representative on the prayer made by the counsel for respondent number 8. Magistrate adjourned today, this term. Give a date after 2 weeks.
My lordship, there is an interim order.
Interim order passed release and is extended till the next date of the speech.
With regard to item number 35 here, this has become infectious in. Then may be withdrawn.
35.
35.
Your name?
B other.
On instructions, Mr. B. Yadav, Learned Counsel for the petitioner, submits that the matter has become infructuous. So accordingly, the matter stands closed, having been rendered infructuous. Next, the registry will transmit a copy of this order to the concerned court below.
Happy to.
Quote for information. Okay. Yes.
Lordship, with the consent of the other side, Lordship, I beg to mention item number 23, Your Lordship. Lordship, we have some difficulties with Your Lordship. Three,
23, somebody has paid for an adjournment.
Lordship.
Somebody paid for adjournment right now. Yes.
26, Lordship. With the consent of the other side, Lordship, I beg to mention item number 26, Lordship.
26.
The engaged counsel is not well, Lordship. So, after 2 weeks, Lordship.
You taken consent of the other side.
Time for the
What is represented? They made by non-counsel for the petitioner. List
after 2 weeks, Lordship.
after 2 weeks.
Okay.
Lordship, supplementary is item 56, Lordship. May I pray for a matter to be taken up at 2, Lordship? Because, Lordship, the application proceeding has already started, and because of some miscommunication, the earlier council withdrew the RSH. We have filed the restoration, Lordship. Urgency is given, which we allow.
56.
56, Lordship. Lordship, yesterday, Lordship had fixed it for today, Lordship.
We'll take up before rising.
Much obliged.
Inform the other side.
Lordship.
Make please, Your Lordship.
Yes.
In regard to item 53, Your Lordship, it may be upgraded. I have taken the consent of the other side. 53 of the supplementary list.
What is the urgency?
Your Lordship only call for the one of the order of the trial court and another postal tracking report. So we have got that. So Your Lordship can dispose it of. And the matter is already fixed on 21st before the court below. So it will be executed.
Okay, we'll take up before rising.
Obliged.
Okay, Lordship. I beg to mention, Lordship, item 6, my senior is out of station, Lordship. Kindly adjourn the matter, 1 week, Lordship.
Item 6.
Lordship.
How much time?
1 week, Lordship.
Just after a week was paid for by non-counsel for the petitioner. Item 6. Yes.
Obliged.
Lordship, I beg to mention item number 14. Your Lordship, in this case, the engaged counsel out of station, kindly adjourn the matter only for that day.
Item number
40.
this matter, if I'm not wrong, it is for continuation of delay.
I'm not aware of the fact, Your Lordship.
Just wait till we call for the matter. We hear the prayer when the matter is called. Next.
Lordship, I beg to mention item number 21, Your Lordship.
21.
The engaged counsel in this matter, Mr. Triki Das, is unable to conduct the matter today due to some personal difficulty, Your Lordship, so some accommodation of time was required. The other side is here as well.
On the prayer made by non-counsel for the
Petition.
also is represented on the prayer made by non-counsel for the petitioner. This one, give a date after a week. Yes.
I have what other side.
Obliged. May I mention from court number 16, as per notification, 16 urgent matter may be mentioned here.
Yes.
So item number 20, Lordships, the IA, 1000 IA, for payment of 50%. Because insurance company filed the appeal and I am for the claimant side. And with the consent of the other side, I have to mention that it may be fixed next 22 of this month.
So we can't pass an order for adjournment because the record is not with us. Mention means that if you want anything to be listed out of turn or something, that we can do. But we can't call for the records from there and pass orders. You'll have to make a mention tomorrow. Give a mention slip tomorrow.
1 week time,
But
maybe.
let's have prayer for adjournment. We can't pass that order. Urgent, this will not be categorized as urgent matter. Urgent means if something has to be taken up, adjudicated, then it's okay. But payment of 50% would not come in that category of urgent. Make a mention tomorrow morning when the court is available.
Lordship.
Lordship, in the earlier matter, there was an interim order. I get 21. Public.
Yes, item 1.
For withdrawal, item 50.
But Mr. E.H.M.R. Chaudhary, learned counsel for the petitioner, and Mr. D. Mazumdar, and the Additional Advocate General for the state, assisted by Ms.
It's not your,
S.
not.
Nath, learned counsel for the learned counsel. Next, upon instructions from the learned counsel for the petitioner, please need to withdraw this revision. Here is allowed, the matter stands dismissed on withdrawal.
Public.
They will file appeal. Instead of filing second appeal, they file revision.
So then the leave has to be.
Not necessarily. Revision is not maintainable, so for appeal, they are at liberty.
Just another line. Well, liberty to approach in an appropriate jurisdiction.
Public.
Item 1 for motion.
May it please your lordship. Lordship, this is a petition filed under section 24 of
We don't
CPC.
see you unless you button up your coat. What is this fashion?
Obliged. This is a petition under section 24 of the CPC, filed for seeking transfer of FC civil case 310 of 26 from the Court of Learned Family Court 2 to the District Judge, Difu Karbi Anglong. Lordship, what happened is the petitioner wife is residing at Difu with her two minor children, aged 5 years and 3 years, and she is also looking after her aged in-laws at that place only. Their schooling and entire upbringing is taking place at Difu. However, our principal grievance is that this FC civil case 310 of 26 filed by her husband was filed with a completely false jurisdiction plea that has been taken in the divorce petition. Lordship, the divorce petition plea is at page number 23, annexure number 8. May I read it, your lordship?
So we are not adjudicating this matter now. Your ground is that you are residing there.
Lordship,
You say that you are residing there.
my
You
we
have
have
two minor
been
children.
we have been residing there since our marriage, lordship. Our last place of cohabitation is at Difu.
Your name? Your name?
H. Talukdar.
Mr. H. Talukdar and counsel for the petitioner. The petitioner, who is the estranged wife of the respondent, is seeking transfer of the divorce petition being FC civil case number 310 of 2026 from the Court of Learned Principal Judge from Family Court number 2, Kamluk Metro, Gauhati, to the Court of Learned District Judge number 2 from Karbi Anglong. Ground assigned is that the petitioner is residing with two minor children, aged 5 and 3 years respectively. You are taking care of your in-laws.
Yes, in-laws also. Because husband's permanent residence is at Dipun. I am staying at with my in-laws.
Also stated that the petitioner is residing with her father-in-law and mother-in-law and also taking care of them at Difu. Next paragraph. You should notice returnable on your date after 4 weeks. Returnable so and so. The petitioner shall take steps for service of notice on the respondent at all the three addresses mentioned in the cost title of this application by speed post with AD. In addition, he is permitted to also send the notice issued by the registry on WhatsApp to the phone number of the respondent and file an affidavit just 2 days prior to the next date of the string. Next paragraph. As an interim measure, the proceedings of FC civil case number 310 of 2026 Special Marriage Act. Special Marriage Act. Pending before the Court of Learned Principal Judge, Family Court number 2, Kamluk Metro, Gauhati, shall remain state. So, however, the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court. Item 2, obliged.
This petition was filed for transferring of the guardianship case from the Honorable District Judge at Dibrugarh to Family Court, Gauhati. Lordship, the marriage between the petitioner and the respondent was solemnized in the year 2013.
Where is the statement that you are paying maintenance to your wife?
Lordship,
Where is the statement in this petition that you are paying maintenance to your wife?
this is a guardianship case, Lordship. This guardianship case filed by the filed in the Honorable District Judge at Dibrugarh.
So this Mayuri Barwa is your wife.
Yes,
Any statement here that you are you have been paying maintenance to her?
the child in my custody since the year 2022. and the opposite part, respondent is
That is
working.
not the question. I'm asking a simple question. Are you paying maintenance?
She has not claimed any maintenance.
Not claimed.
She is the principal of a school. She is running a school at Dibrugarh. Lordship, kindly peruse the page number 44. The child born in is suffering from the speech delay, and he was treated in the year 2022 in the Gauhati. And subsequently, the minor child was admitted in Gauhati in presentation of kindergarten school, page number 45. Kindly peruse the page number 45. 45 to, and he is enjoying with his friend and relatives at in Gauhati, and still constantly he is permanently staying in the under the jurisdiction of the Kamrup at Gauhati. Lordship, what happened? Meanwhile, after a gap of 4 years, the respondent has filed this petition before the Honorable District Judge, and the minor child has also promoted, and at present he is pursuing his studies as Don Bosco downtown school at Gauhati. Kindly peruse the page number 69 onwards. And he is showing good results in his studies. And moreover, he is going constantly taking the care of his speech delay, and his therapy session is present in the CRC Composite Regional Center, Development and Rehabilitation, Empowerment of Persons with Disability at Gauhati, and also at AIMS and Gauhati. Lordship, under section 9 of the Guardianship Act, under section 9 of the Guardianship Act says that court having jurisdiction to entertain application. If the application is with respect to the guardianship of the person of the minor, it shall be made to the district court being jurisdiction in the place where the minor ordinarily reside. Lordship, minor child is residing with his father under the jurisdiction of the Kamrup since the year 2022, and he is pursuing his studies in the different school at reputed school at Gauhati, firstly at presentation of school Gauhati, and thereafter the presently studying in the class grade 1 and the downtown school at Gauhati. Lordship, from the perusal of the section 9, it is crystal clear that Dibrugarh has no jurisdiction to enter that petition. They ought to have been transferred to the Honorable Principal Judge Family Court for trial. Moreover, the constant medical treatment of the child who is suffering from the delay in the speech is going on Gauhati. And kindly peruse the page number 71 onwards. Kindly peruse that document. In paragraph number 3rd, he is going the constant speech therapy. Kindly peruse that document. He is going the constant speech therapy, structural socialization. Page number 77. Kindly, Lordship, page number 77. Based on the comprehensive and updated multiplicity assessment, it is strongly recommended that he requests intensive, regular, and long-term intervention, including constant speech therapy, number 2, structural socialization training, number 3, behavioral modification program, number 4, ongoing occupational therapy, and regular physiotherapy, functioning of the correction of poor posture. And there is a organization held that it has been constantly observed that Master Ryan's Bharadwaj demonstrates significantly better participation, cooperation, and responsiveness during therapy session in the presence of his father. And speech therapy is also going in AIMS at Guwahati. And his training session is going on his speech therapy at page number 76. Photographs are also there. And schooling where he is presently studying after his presentation school at Gauhati, and he is pursuing his studies, and he is developing his studies in Gauhati, who is in the constant care and the function of the father. And I am staying in a joint family. And section 1 clearly
DK for the counsel for the petitioner. The petitioner, who is the constrained husband of the respondent, has prayed for transfer of the guardianship proceedings being missed within bracket G, bracket for case number 4 of 2026, from the court of Learned District Judge, Dibrugarh, to the court of Learned Principal Judge, Family Court, Kampu Metro at Gauhati. Next paragraph. It is projected that the minor child is residing with the petitioner at Gauhati, where he is being treated for various therapeutic, THERAPEUTIC, therapeutic and rehabilitative services. It is also projected that guardianship proceeding is required to be instituted only at the place where the matter is filed. Accordingly, issue notice returnable on so. Due date after 4 weeks, 15 of the petitioner shall take steps for service of notice on the respondent by speed post with AD. There's an interim measure until the next returnable date. Other proceedings of Miss in bracket G, bracket was case number 4 of 2026, pending before the Learned District Judge, Dibrugarh, shall remain stayed. However, how the petitioner shall cause production of a certified copy of the order before the said learned court in the order to the notice of the said learned court. This talks to item 3.
Item 3.
But in this case, I have challenged an order passed by the Learned Executive Court under section 47 filed by us, which was rejected. And what happened in this case, there was a partition suit.
Was the decree, you say your case is that there was no decree for recovery of possession.
Yes.
Where is that decree?
Lordship may straightway come to first page 105. That is the decree passed by the trial court. Starts from page 90 and the relief is at page 105. Lordship has seen page 105.
Yes.
The first in the order of paragraph 1, for declaration that they have right, title, interest and possession the suit land and confirmation of possession therein as co-sharers on the land under the number censor of the plaint and recovery of possession of the suit land described in schedule C and D. We were in possession of schedule C and D, my lord. So there was a decree by the trial court for recovery of possession, although it was a partition suit. Then we preferred an appeal. We can. appeal was preferred by the co-sharers. Page 117, the judgment of the appellate court starts, my lord.
Just a moment.
Suit was for partition, my lord. If your lordship desires to see the prayer made in the plain.
Mr. D. Majumdar, Learned Senior Counsel assisted by Mr. S. Vishwasan, counsel for the petitioner. Where is the impugned order?
Impugned order is at page 253, my lord.
By this revision under section 115 of the CPC, the petitioner who projects that he has been evicted from the suit premises has and had filed an application under section 47, read with section 146, 144, and 155 of the CPC, 151 of the CPC, which was rejected. Next, the case projected by the petitioner is that the he was not arraigned, that the petitioner was not arraigned as a defendant in title suit number 37 of 1989, which was a suit for partition. Stop referring to the prayer made in the plaint. It is submitted that the prayer was for confirmation of possession and was not for recovery of possession. However, while the suit was decreed on was allowed and decreed by order dated judgment and order dated 23/11/2009, the order at serial number 1 by order at serial number 1, decree for recovery of possession of the suit land described in schedule C and schedule D was ordered. Accordingly, this
one submission on appeal, the recovery of possession was removed.
Where is that?
Well, page 140, appellate court's order, my lord, operative part.
140. The defendants, the co-defendants who were aggrieved by the said judgment and decree preferred title appeal number 1 of 2010 and the learned additional district judge number 4, Roman 4, FTC from a Kamrup from a Gauhati, by appellate judgment and decree dated 10/10/2013. Page number?
Page, it starts from page 117, my lord, and the operative part is at page 140, modified the decree, my lord. Page 140,
140.
my lord. At the bottom, Lord, we find para 63. In the result, the appeal is dismissed on contest with some modification. The impugned judgment and decree so and so is hereby affirmed with some modification. For
appeal
declaration
was-
that the
Dismissed from however, comma, with modification
in this modified decree, there is no decree for
with
recovery.
modification and at para 63 of the appellate order, judgment and order, comma, the decree for eviction from the suit premises described in Schedule C and Schedule D of the plaint was not granted.
Not bad.
Full stop. It is projected that
Just one more mention, if
which
you
date you were dispossessed.
we were disclosed in 2018, my lord. Lord, may just may like to mention page 159, 159,
159.
159. Executing court has passed an order 31/7/2018. Dictated for discussion.
Yes.
Now, by this order, since their execution case was dismissed, that was revived. After reviving page 166, concluding part of this order,
159 you said.
we starts from this order, starts from 159. At the bottom, let's see the date 31/7/2018.
Yes.
Now, its concluding part is at page 166. There the executing court writes that there is a decree for recovery position, so issued writ of delivery position. Last paragraph, my lord, at the bottom. Let the writ of delivery position with regard to Schedule C and D.
It is further submitted by the learned senior counsel for the petitioner that though by the appellate judgment and decree comma the decree passed by the learned trial court for decree of recovery of possession was deleted. However, comma, this is in which court?
Civil Judge 3, my lord.
Huh?
Civil Judge 3, Kamrup.
Civil Judge 3. Right. The learned Civil Judge number 3, the Civil Judge in the Senior Division, number 3, Kamrup Metro, Gauhati, by an order dated 31/7/2018, passed in the proceedings of T/XEX, case number 1 of 2010, revised the execution proceedings for recovery of for recovery of possession. You're referring to page 163,
Yes, ma'am.
that last
Page 166, ma'am.
it's
66, the bottom paragraph.
and writ of delivery of possession with regard to Schedule C and Schedule D properties, as mentioned in Schedule of the plaint of TS number 37 of 1989, was reissued for carrying out execution and restoring possession of the degree holders in respect of Schedule C and Schedule D properties.
The petition entered in post law, he could product the entertain.
Next,
Without any could post for आगे dispose those products. Which possible.
being this 47 application was filed prior or later
My lord,
After your eviction, you have filed this 47 application, or you later it was filed?
after disposition.
After disposition.
Right.
So date of disposition is?
My lord, we have not mentioned the day, but after this order, we have mentioned at paragraph page 49. After this order, we were ousted. And incidentally, petition was filed before the executing court. They did not entertain. We came before lordship. Incidentally, on that day, your lordship passed an order that please entertain the petition. Before we could go and approach the court, everything was done. We were evicted. So, this happens in execution cases, my lord.
You have annexed that order? Yeah.
That mention is there, my lord. Madam, in the second petition, if your lordship kindly takes up similar petition, madam. Page 49, in the second petition, page 49. Your time. We
Yes.
annex that order. Page 79 is your lordship's order. Yeah, in the other petition.
79.
Not
No.
79, I'm just the PT. My lordship may kindly turn to paragraph 6 at page 7. There
Hmm.
we have specifically mentioned that.
Page number?
Page number 48. Page 48, madam. Page 48 at the bottom. Unfortunately, if the lordship has got me. Unfortunately, the said application was not entertained, for which the applicant was compelled to initiate proceedings under Article 227 of the Constitution of India, which was registered and numbered as CRP number IO number so and so. The Honorable High Court, by an order dated 3/8/2018, directed this Honorable Court to entertain said application and to pass necessary order as may deemed fit and proper. Unfortunately, however,
Where is
before
that
the
order?
applicant's application could be entertained, applicant was already disposed.
Which page is that order?
And,
Annexure J, where is that page?
the order, madam. Annexure J, madam. Just
Page.
Annexure J.
Find out from the index, it is easier.
You might have different part of it. It's actually in the index,
And
somehow
if
it is
the
not,
index-
it
if
is
the
short,
index-
but
If in the index it is not there,
it's
then there is a place
very
where you can,
difficult even if from the executing court's order, so many orders have been annexed.
so then there is a place where you can throw that file.
One twenty-nine, madam.
129.
Yes.
By referring to the documents annexed to CRP 66 of 2026, it is submitted by the London Senior Counsel of the petitioner that on coming to know about the certain eviction, the petitioner After collecting certified copy of the relevant orders, filed, they wanted to move two petitions before the learned executing court on 2/8/2018.
Yes.
To object to the execution. However, the same was not received by the state learned court. And accordingly, the petitioner had to move this court by filing CRP IO 261 of 2018. And this court, by order dated 3/8/2018, directed the learned executing court to accept the said applications. It is submitted that by the time the petitioner approached the learned executing court along with a copy of the order dated 3/8/2018, asked in CRP IO 261 of 2018, the eviction process was carried out and the petitioners were dispossessed from the possession of the said property. Thereafter, the petitioners filed an application under section 47 CPC objecting to the 47 read with section 146, 144, and 151 of the CPC against the object to the execution. Mr. However, said petition was dismissed by order dated 8/4/2026, asked in VJ case number 620 of 2018, in connection with TX case number 1 of 2010. Next paragraph. As a primary case has been made out by the petitioner, the court is inclined to issue notice returnable on your date after 4 weeks, returnable on so and so. The petitioner shall serve notice on the respondents by speed post PCD. Of the learned instructing counsel would be liberty to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next, list on so it's
Well, I prayed for stay of the impute order.
Yes.
Yes, if lordship can pass the status quo so that they don't take any extraordinary step to make
You have to file an injunction application.
Well,
Status
we
quo will
should
not
file-
be
True,
appropriate.
we should file an application.
Status quo is creates more problem than solutions.
We'll file appropriate.
See that. The second item, Mr. D. Mazumdar, senior counsel, assisted by Mr. L. Biswal, and asked the petitioner, the background facts in this case is similar to the one which is passed in CRP 65 of 2026.
Here's the 65.
Therefore, not reiterated in this order. Next slide. Issue notice returnable on so and so. Same steps, extra complex steps in 2 days. Postal receipt number, track report, list on so and so.
Public.
Item 5.
Yes.
Lordship.
Lordship, this revision petition prefer against the order dated, Your Lordship, 2012-2025, whereby the appellate court dismissed my appeal, Your Lordship, and affirmed the trial court injunction order, whereby the trial court restrained me
Where is
from
your plaint?
Lordship.
Where is the plaint?
Lordship,
Plaint
play
is at which page?
Lordship, plain is that page 16, Your Lordship. In short, Your Lordship,
Where is your injunction application?
injunction application is Lordship, page 43, Your Lordship. Page 43.
You were granted injunction?
Yes, Lordship. The plaintiff will grant the injunction, Lordship. I am defendant number 1 and 2, Your Lordship.
The appellate court interfered.
Not interfere, Lordship.
Then
Affirm the trial court order, Your Lordship.
why you filed this application? You are the plaintiff.
No, I am not plaintiff, Your Lordship. No, I am defendant number 1 and 2, Your Lordship.
You are
Defendant number 1 and 2, Your Lordship.
respondent number 1 and 2.
Yes, Lordship. In the plain, in the suit, Your Lordship, I am defendant number 1 and 2.
Number 1 and 2.
Here, Your Lordship, what happened, Your Lordship? AEGCL issued a tender, Your Lordship, and I secured that tender proceeding. And some contract work has been carried out with the help of some subcontractor, Your Lordship. With the plaintiff and 3 and 4 other defendant, Your Lordship, and in the also respondent, Lordship. And Lordship, the plaintiff have done some work, Your Lordship, with me and defendant number 3 and 4, Your Lordship. And without raising any proper bill, Your Lordship, he has filed a title suit, and that he got the injunction, Your Lordship, restraining the AEGCL from disbursing that legitimate amount which would I am receivable, Your Lordship. And now which is against the Lordship the points of activity of contract, Your Lordship. There is no any contractual relationship between that plaintiff and the AEGCL, Your Lordship. I am the one who got the tender of the Lordship. And they have not raised any bill, Your Lordship. The trial court as well as the appellate court, Lordship, misappreciate that evidence, Lordship. Lordship, I am relying on their document, Your Lordship. Page number 30, Your Lordship.
What is the tender value?
Tender value, Your Lordship, probably
More than 15 lakhs.
yes, Lordship, more than 50 lakhs, Your Lordship.
So if they are restraining it for 14 lakhs, what is wrong with it?
Lordship, here is the main problem, Your Lordship. Lordship, they are claiming for 14 lakhs 81,000, Your Lordship, which is not his amount, Your Lordship. He have not raised any bill, Your Lordship. I am relying on his
Just
documents.
call them and bring them here for mediation.
Your Lordship, for my satisfaction, Your Lordship, here is the bills, Your Lordship.
You don't suffer anything. It's just not to disburse.
No, Lordship, he sought for injunction for 14 lakhs 81,000, which is he is not receivable, Your Lordship. he repeatedly misled the trial court, your lordship, and trial court even my plea has not considered, your lordship. He raised the bill against that whom, your lordship, against the person, your lordship. Person is that one of the subcontractor. He work with him, your lordship. So I am not responsible for that, your lordship.
Where is that statement in the plaint?
Lordship,
Where is that statement in the plaint?
your lordship, in my objection, your lordship.
So in the plaint, what is that they are projecting?
They are protecting their code for, your lordship.
If you come to page 20, paragraph 3,
Page.
page 20, paragraph 3, they said that the work which was sublet by the company to 1 and 2 was again sublet to the plaintiff. That is how they are wanting.
Page number 30, your lordship.
20,
20.
paragraph 3.
Paragraph 3. And that he has been instead of the plaintiff number order to engage himself in developing the infrastructure scenario as a contractual work, as well as the supply of some billing and losses, and then and transport of 1 and 2, and also producing certain not from the 5 and
Then in paragraph 5, they say that you have acknowledged their debt.
your lordship. Yes, lordship. I'm acknowledged that I'm engaged in, your lordship. There is that work order, your lordship.
You prefer an application before the trial court have a
No,
mediation?
lordship, can you bear with me, lordship?
No.
Here, lordship, page number 32, lordship. Have a look, lordship. Page number 32, your lordship.
You get the work done and you vanish.
Lordship, lordship, give me some time, lordship. I will satisfy your lordship.
You see, if you're an honest businessman, what will you say? That is not entitled to 10 rupees, but the work done was 5 rupees. That
Lordship,
is-
let him raise the bill, your lordship. Without raising a bill, how can I release the fund, your lordship?
See, you are yourself saying that you did not give them the contract. How can you give them he can give you a bill?
Lordship, let him first release, your lordship. Here's the MO, your lordship. Page number 42, your lordship.
Not disturbing the injunction.
Lordship, here is the bill. Lordship, here is the MOU, lordship.
If you have some honesty, you will just tell him that please come and settle the matter at the table.
Your lordship,
People are only one telephone apart.
your
You
lordship,
just have a call and then have it settled. That you don't want to do.
your lordship, page number 30, lordship. Have a look, lordship. Please, lordship.
We have seen that.
Lordship, here is that MOU, lordship.
Had I not seen it, I would not have referred to a particular page, particular paragraph.
Lordship.
And your admission. If there is no bill, how will you admit? That itself shows that unscrupulous practice is being followed.
Your lordship, there is a two subcontractor, lordship. He worked
Why
with
would
me
you
and
acknowledge? Just tell us.
lordship.
Why would you acknowledge?
Lordship, I will, lordship. I will acknowledge him, your lordship. Let him first issue raise the proper bill, your lordship. Without
Call him over telephone. Ask your client to call them over telephone and have it settled.
lordship, then issue a notice, lordship. I will serve a copy
If you're dismissing it. If you want, you can just keep it pending for a week, but nothing more. But we're not inclined to issue notice. The contractual dispute, you don't pay them and then you say that they have done the work, they have not done the work through me.
Lordship, I'm ready to pay, your lordship. Let him first raise the bill, your lordship. Without raising bill, how can I suppose, your lordship, he has done the work, your lordship. Where the several subcontractors well done their work, lordship.
Had I known all this,
Lordship.
of how to do business, I would be in business. I would not be here in the first place. Those things I don't understand. I just understand that there's an acknowledgement. Once there is an acknowledgement, it's something which falls within the meaning of Section 18 of the Limitation Act. That is all my knowledge is.
Lordship, you have some problem.
Business, I don't know. I would have done it.
Lordship, we are trying to done it, your lordship, but we have several
Call them
times.
for mediation. You just give them a call them for mediation and settle the matter.
Lordship, then
You see,
Lordship.
your bill is not restricted to 14 lakh rupees. Your entire work bill for the project will be running into huge money.
Lordship,
So 15 lakh, how does it dent you?
Your lordship, this amount is not receivable by the entire amount is not receivable by him, your lordship. here he is falsely claiming, your lordship, 14 lakhs or 14 lakhs 81,000,
You
your
see,
lordship.
why will I say he is falsely claiming? That
Lordship,
means I've done my.
I'm demonstrating his claim, your lordship. Let me go. I'm
You
relying
forget
on
that.
his documents.
You forget
Lordship.
that.
I'm not relying on the
You forget
my
that.
documents, lordship.
In the morning when I came here,
Lordship.
I did not find this pen.
Lordship.
So I asked my courtmaster, he found out from there and gave it here.
Lordship.
That means, you see, I am aware that yesterday when I went, I left this pen here. Today morning when I am sitting, I did not find this pen here. And I requested my courtmaster to find it out and they found it. If you are saying that the claim of A rupees is false, that means you know that he has done a work of B rupees. That you are not stating anywhere.
Lordship.
I have seen in your.
I am not disputing that way, lordship. I am disputing this way, lordship. He done with some work with a 2 and 3, your lordship, and with me, your lordship. I have done here in this lordship, in the MOU, lordship, signed by him, lordship. Here clearly stated, your lordship. Beyond the lordship, that this quantity has been above quantity has been already finalized with that Rian Enterprise that is 10/9/2022 in presence of that executive of the MS person.
Page?
Page 42, your lordship. Page 42, your lordship. What should I find, your lordship? Page 42, your lordship. Above the quantity already finalized with that Rian and
just now.
42, your lordship. 42.
Yes.
Yes, lordship. Here, your lordship, MOU signed by that by me and the plaintiff and respondent number 3 and 4, your lordship. Above quantity already finalized with the MS Rian Enterprise dated 10/9/2022 in presence of the executive of the MS person. MS person means lordship 2 and 3, your lordship. The respondent number 2 and 3, and the MS Salazar is that petitioner, lordship. Beyond this work done to be measured separately with the civil engineer of MS Salazar in presence of that Rian Enterprise that we finalized on Monday, and according to the final bill to be raised or submitted by the Rian to the MS Salazar for payment, your lordship. After this MOU, lordship, he has been not raised any bill, your lordship. He restraining the amount of which is not receivable by him, your lordship. If I go by his document, your lordship, page number 34, your lordship. His document. I'm relying on his document, your lordship. This is the bill raised by that plaintiff. To whom, your lordship? Fortune, your lordship. Fortune, your lordship. Amount is 16,22,000 euro. Yes, lordship.
Yes, you have made out a case.
Lordship.
You have made out a case for notice. Well, Mr.
T. Gogoi, your lordship.
T. Gogoi, learned counsel for the petitioner. Next, I agree by the order of injunction dated 6/2/2024, passed by the learned civil judge in the senior division, that is number 1, Kamrup Metro, Gauhati, initial case number 111 of 2024, in TS 50 of 2024. The petitioner had filed an appeal, which was registered as Miss Appeal number 56 of 2024, which was dismissed by order dated 20/12/2025. Next, by the order of injunction, the Where is the order of injunction? 54.
Order of injunction, your lordship.
54.
113, your lordship. The trial court. Order at 7/9/2024, your lordship.
Seven, 9, 24. Page number?
The 113, your lordship, 113.
Back ready. So the order will be 7, 9, 23. Passing 111. Ready. State order, there is 7, injunction order, there is 7, 9, 24. Mandatory and temporary injunction was granted. Prohibiting respondent numbers 5, 6, 7, and 8. And their affiliates, representatives and associates from releasing the bill amount of rupees 14,81,879 in favor of the defendant numbers 1, 2, 3, and 4 till the final resolution of the dispute. So on dismissal of the appeal, this revision has been preferred under section 115 of the CPC. Issue notice, including notice on the prayer for interim relief, returnable on Ms. Hogan, you will be accepting notice
Yes,
for the
I'm
state,
appearing for the department, your lordship.
for the department.
So respondent number 5, 6, 7, and 8.
If standing for the AEGCL accepts notice on behalf of respondent numbers 5 to 8. Requisite extra copies of the revision petition with all enclosures be provided to her within 2 days. After the petitioner shall take steps for service of notice on the respondent numbers 1 to 4 by speed posting with AD. The land counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next, for a list on so and so. You have issued a notice on the prayer for interim relief.
Lordship. Alright.
For motion, item 7.
Let me. My lord, petitioner's father purchased 9 liters of land, my lord. Behind, backside 4 happens is in position, my lord. Backside 4.5 is in position. Front side 4.5 was enclosed by the defendants, my lord. So I filed a suit, my lord, suit was decreed, and up to High Court, my lord, second appeal, it was upheld. Now, when the decree was put in execution, my lord, the Senate, my lord, executing court did not said that, my lord. And he had this honorable court, my lord, while last time argued before the honorable judge, my lord, he asked me to submit the copy of the report, my lord, and Najir. I got that, my lord. If your lordship will see first, my lord, there is impugn order at page 108, my lord.
Yes.
My lord, file petition so and so, it is stated that the concerned large model civil library went to a suit land but could not show the suit land to a decree holder. This is absolutely forward, my lord. The court examined the large model and started doing execution of decree. he measured the length and breadth of the portion from land, decree holder. The breadth side, front side was 9.5 feet or of 10 feet. The position of the warrant, exhibit 1, there is no mention of length and breadth of the decreed land. As such, he could not properly identify the boundaries of suit land and could not hand over the position of the decreed land to decree holder. Further, it is stated that the predecessor decree holder purchased the suit land, which clearly mentioned that the sale deed number so and so breadth of purchase to be 9 feet. To sell deed is 9 feet. Further, it is also stated that the decree holder has also filed a suit for adjacent plot of land, and the said suit was registered so and so, and a decree was already executed. In the said decree, breadth of the suit land was clearly mentioned, and there was no difficulty at the time in showing the decreed land. But the decree holder, in the instant case, did not mention the length and breadth of the suit land, and as such, the last model could not show the suit land of decree holder. Stated that the length and breadth of suit land is required to be mentioned. The decree is most essential for execution of decree. Otherwise, the decree holder cannot enjoy the fruit of the decree. The mistake of the decree holder is bona fide, and the advocate did not mention the length and breadth of the suit land due to oversight, and the same is clerical and not intentional. Hence, it is better to allow the decree holder to amend the decree and thereafter proceed the execution of the decree. I have heard the learned counsel for the decree. By petition number so and so, decree holder intends to amend the decree incorporating the length and breadth of the decreed land in the schedule decreed land so and so. The petition number filed so and so. Then next, amendment of the so and so. It mentioned by the section 152. Then reference to state section 152 permits a court to clerical arithmetical mistake in the judgment decree other arising from their decreed expressly permission. However, in this case, is the executing court and not the court who passed the decree, state judgment and decree. Executing court cannot go behind the decree and has to execute the decree in terms of the relevant judgment and decree already been passed. Hence, in my considered opinion, 152 does not empower the executing court to amend the decree in the execution of the proceeding. As such, so and so most notice going to go and pass the judgment and decree of the so and so. Now, my lord, if you also see the report of the Mondal and Nazir, my lord, Nazir report, if you also see, my lord, that's the otherwise, my lord. At second page, my lord. আজি ইংৰাজী তাৰিখে তফচিল পঞ্চ ভূমি পুনৰ জোখমাপ কৰি পুনৰ জোখমাপ কৰাৰ সৈতে মিল পোৱা যায় আৰু নতুন জমি আদালতৰ দেৱানী নাজিৰক চিনাক্ত কৰি দেখাই দিয়া হয়। দেন নাজিৰ ৰিপৰ্ট ইংৰাজী ইমান তাৰিখে দীক্ষিতাৰ লাটমণ্ডল জড়িত 4জন জাৰিকাৰক আৰু আৰক্ষী বাহিনীৰ দখলী পুৰণা উল্লেখিত উপস্থিত জনোৱা হয়। লাটমণ্ডলে তফচিল ভূমিটো জুমি পুনৰ জোখমাপ কৰি পূৰ্বতে জোখমাপৰ সৈতে মিল পায় বুলি উপৰোক্তভাৱে লিখি দি জমি চিনাক্ত কৰি দেখুৱাই দিয়ে। লাটমণ্ডলে জোখমাপ কৰি দেখুৱাই দিয়া জমিৰ ভিতৰত নলা অন্তৰ্ভুক্ত হৈ থকা দেখা নগল। বিদ্যুৎ বিভাগৰ কৰ্মচাৰীয়ে বিদ্যুৎ যোগান ব্যাহত কৰি বৈদ্যুতিক তাৰৰ ওপৰত থকা গছৰ ডাল কাটি দিয়ে আৰু তাৰ পাছত চৰ জমিত থকা মূল গছজোপাখন কাটি দিয়া হয়। ইয়াৰ পাছত দীক্ষিতাৰ দোকান ঘৰৰ ওপৰত থকা টেণ্ডাৰ পক্ষৰ দোকান ঘৰৰ বাৰীহাত শালৰ টিং মানুহ লগাই আঁতৰাই চেষ্টা কৰাত টেণ্ডাৰ পক্ষই জনাই যে সেই বাৰীহাত শালৰ টিং কটাওঁতে নাইবা আঁতৰাওঁতে যদি টেণ্ডাৰ পক্ষৰ জমিৰ কিবা ক্ষতিপূৰণ জৰাজীৰ্ণ তাৰ পৰা টেণ্ডাৰ লাগিব, অন্যথা উক্ত টিং কাটিব নাইবা আঁতৰাব দিয়া নহ'ব। দিছ ইজ দ্য মেলডি। দীক্ষিতাৰে উক্ত প্ৰক্ৰিয়াত হ'ব পৰা ক্ষতিপূৰণ দিবলৈ কোনো ধৰণৰ মান্তি নহয় বুলি সহযোগিতা নকৰিলে। দীক্ষিতা আৰু টেণ্ডাৰ দুয়োপক্ষৰ জমিৰ থকা জৰাজীৰ্ণ দোকানখনৰ অৱস্থালৈ লক্ষ্য কৰি দীক্ষিতাৰ সহযোগিতা নোপোৱাত টেণ্ডাৰ পক্ষৰ ভাৰতীয় দোকান ভাৰী অহা অংশ আঁতৰাব পৰা নহ'ল। ইতিমধ্যে টেণ্ডাৰ দোকান ঘৰ আঁতৰাই দীক্ষিতাৰ যোগাযোগ বাধা প্ৰদান কৰে। Thing is that can be cut. Why did you file a petition for amendment? Well, that is not necessary, my lord, because it is there in the cell deed that should be found, my lord, in that order. 9 feet. Then you could have moved the trial court for withdrawal of this 152 petition. Yes. No, that is not decree, my lord. The Honorable Court will direct execute the decree, my lord, as per because Latmondal has shown the portion, my lord.
We understand, but you see, it is your petition.
That is correct, my lord. That I'm not disputing. But the existing court, my lord, refused to execute
What we can do is that you file an affidavit saying that this has come to your notice, and then this till that petition of 152 is there. We can't pass a contradictory order unless you bring it on record.
Yes. This report,
This report you have to bring it, and
I shall bring
the
it.
effect that this is
All right.
maybe because of some error this has been filed 120.
Yes. And moreover, my lord, it is proved that it is 9 feet breadth. 9 feet breadth, because backside land is there with him.
That's the difficulty. The council does not read the records
That's correct.
and made a mess of everything.
I shall file an affidavit, my lord.
File it and bring it on record, because then this petition would be inconsistent.
Yes.
You have to take a plea that you don't press that 152 application is not required.
Not
Review of that.
Yes.
And without that, we can't touch it.
If necessary, my lord, I can bring the salary, copy of the salary also I can file. Because that was,
Depends
they
on
are,
how you project.
yes.
We just adjourn this matter
Yes.
on the prayer. When should we list it?
2 weeks, let's wait for one.
Huh?
2 weeks more time will happen. After 2 weeks.
Okay. Mr. G.N. Savala, learned senior counsel, assisted by Mr. Estodi, learned counsel for the petitioner, submits that pursuant to order dated 20/4/2026, he has received a copy of the report of the Lat Mandal,
Latmandal Nazir, my lord.
Lat Mandal and Najib. And accordingly, it is submitted that he may be granted liberty to bring the same on record by filing an affidavit. So prayer is allowed. Next, I speak for list after 2 weeks.
Item 8.
Yes, Mr. Ghosh.
My lord, in this case, my lord, I have filed an application under Order 1, Rule 10, my lord. That was rejected.
Where is the order?
Ordered it
First,
at
your petition. Where is that petition?
petition at page, my lord, 38.
38.
My lord, text is this, that
You are a stranger,
I'm not a stranger, co-owner,
co-owner.
co-sharer. My contention is that the contract which has been made in between the plaintiff and defendant number 1, 2, and 3 through power of attorney holder, defendant number 4. Suit for specific performance of contract was filed. Our claim is that the suit for specific performance of contract which has been made by attracting the land of the co-sharer also.
The land is 15 bigha, 2 kata 7.5 lacha.
Yes,
It includes your share also.
yes.
Where is the statement here?
The statement, kindly see the order, it reflects in the order also.
Petition,
In
petition where you
petition,
said
my
that.
lord. In the petition at page 38.
Where is that statement in the petition?
At page 39, kindly see, my lord. The original, paragraph 3, the original owner of the suit land was Lavanya Kundu, and after the death of Lavanya Kundu, suit land and other land devolved on his 5 sons, namely so and so, so and so. How it has been devolved, that is statement.
No,
Then,
just tell us that you are a sharer in that land, just that statement.
yes,
How it devolved, we don't know.
6. That paragraph 6, that Sir Satyanjan Kundu died leaving behind so and so.
paragraph 12 and page 41. That one years of late Popular Kundu, namely so and so, and 1 years of so and so, agreed only mutated their name in respect of the land of Lavanya Kundu, which include the suit land behind the back of other years of 4 sons Lavanya Kundu, including the present petitioners, who are the heirs of so and so.
Page 41. Reading where?
Paragraph
12.
page 41, paragraph 12. And paragraph 15 is the specific statement that the petitioners are the co-owners of
This
the
is what
suit,
you want. Okay.
and in presence petitioners
It says Ghosh counsel for the petitioners. The case of the petitioners is that the respondent number 1 has filed a suit for specific performance of contract for enforcing sale of the suit land measuring about 15 bigha, 2 katha, 7.5 lesser, more fully described in the schedule of the plain. And accordingly, the said suit was registered as PS number 4 of 2025, pending for disposal before the court of Nanak civil judge within bracket senior division bracket 2 Biswanath. Next, the petitioners project that by way of inheritance and claiming to late Satya Ranjan Kundu, Satyaranjan, Satya Ranjan Kundu, the petitioners are owners of the suit land. Accordingly, on coming to know about the pendency of the said PS number 4 of 2025, the petitioners had made a prayer before the learned trial court under order 1 rule 10 within bracket 2 CPC to read with section 151 CPC for being implemented as co-defendants. The learned trial court by an order dated 7/8/2026 passed in TS number 4 of 2025. Rejected petition number 1121 of the 2025. Was the application under order 1 to 10(2) read with section 151 CPC of the petitioner. Only that they are not necessary parties. Learned counsel, next. If you notice, returnable on.
My lord, there is two lines, my lord, in the schedule, my lord. One is 15 bigger 2 kata 7.5 lecha, another is 23 bigger 4 kata 7.75 lecha.
Where is that?
Page 14, my lord, in the plain.
And this two. The schedule A is of 15 bigger.
Hmm?
Schedule A,
In our petition also,
schedule A,
schedule A.
okay, schedule A and schedule B consists of 23 bigger.
Both schedule A.
Hmm?
Schedule A includes both.
The schedule A includes both. Also plan. In schedule A, one is 15 bigger, 2 kata 7.5 acre. The other is 23 bigger, 4 kata 7.25 acre. But except in interest for some of the notes on the following by if for PDD. And then from petitioners are taking is at liberty to collect the trophy visit number. Civil hospital track report prior to the next day of the state. Next. Till the next returnable date. As an interim measure for the proceedings of statute number 4 of 2025. Pending before the learned civil judge in the senior division. Shall remain state. Next, petitioner shall release a certified copy of the order before the learned start to bring the order to the notice of said learned. This comes first.
Next two case is also same, but next two case is also same, but here in this measurement of the land is only different. Because there are three contracts has been made by three persons, three sharers separately.
Just I keep a piece of paper and give it to the court master because my secretary has left. And also give the suit number.
Suit number.
And your petition number. Three things.
Eight, nine, 10.
Take a short break and come back.
Item 11 for motion.
May I please? My lord, my petition for my lord calling a unlisted witness rejected by lord. Petition is page 42, my lord, and impugn order, my lord, is page 50.
You are the plaintiff or the defendant?
Plaintiff, my lord. I wanted to prove that in my land, one Indira Awas Yojana house was granted and it was built in the year 1988-89, which is the record of the my lord is Gauhati Panchayat. So secretary is supposed to my lord prove the case if allowed, and the petition was not allowed.
Where is the order dated 9/7/2025?
Date order, my lord, I have not included, but I include only the order dated 23/3/26.
But then, Mr. Chauhan,
My lord,
you filed an application for recalling of the order dated 12/8, for recalling of the order dated 9/7/2025.
my lord,
That was rejected.
my lord.
And this 9/7 order is not before us.
My lord, then my lord, one week time we granted, I obtained certified copy and filed my lord, my application.
Two orders, my lord, 14-10-25 and 9-7-25.
Then Mr. Chauhan, right, you see, the written statement come counterclaim
Yes,
was filed by the defendants on 7/2/2020.
ma'am.
So therefore, every likelihood that in 2020 only the issues were framed.
This was framed, my lord, and PW
No,
already.
no,
applied.
we're
PW
just asking, the issues were settled on or before, in the month of 2020, in the year of 2020. List of witnesses are to be provided within 15 days of the settlement of issues. So therefore, that is gone. In your, when your evidence was recorded, you never produced the list of witnesses or did not allow
This is,
these
that
witnesses
is,
to be
this is,
examined.
this is my, less than my part, my lord, because the list of witness, that.
No, but
Not
see,
there.
second thing, you filed a petition earlier that was rejected. You filed a second application that was rejected. That is, what you call, 9/7 and 14/10/25.
Yes.
Correct. Now you're asking for recall of that order, those two orders. Even if you bring these orders of 9/7/25 and 14/10/25, but still the fact remains that within settlement of the settlement of the witnesses, the settlement of the issues, the witnesses were not brought, and these witnesses were not examined before closure of your plaintiff evidence. At the stage of defense witness, now you want to bring the examine other witnesses. You have not even stated here that how many defense witnesses were examined.
Three, madam.
Three were examined.
No, three PWs. Defense not examined.
Yes,
PW
at the
not
stage
examined.
of the court is writing here at the stage of defense evidence.
Yes, it is for defense evidence. But defense is not produced, my lord, not submitted.
You see the order page 51. This is not disputed. Page 51, paragraph 7.
My lord, yes, it is for defense witness, it is written, I have seen, madam.
This you are not challenging that the court has given a wrong order. You have not produced the order sheets. At the defense stage, you can't be allowed to give plaintiff evidence even under orders.
My lord, generally, my lord, my official witness call after, my lord, my lord, after offering my lord, yeah, witnesses.
Yes, sorry, therefore we have even amended the civil court rules and orders. This is not a practice that after one witness, you will call another witness and thereafter you will call another witness.
Those examined, my lord, already listed witness. Only, my lord, the secretary of Gauhati will not listed witness, admittedly not witness, and that is why petition was filed.
You see, apparently what you are stating is incorrect. I'll tell you why. You say that all three witnesses were examined of PW.
Well,
Then you filed an application for examining further witness. That will only come when you close your evidence. Then only further witness will come. After you examine three listed witness, the trial court will not pass an order fixing another date for plenty witness.
no.
Definitely not.
That is why my lord petition was rejected.
So therefore, the court's order that this was filed at the defense evidence stage is correct.
Yes, after finishing the.
And we can't allow you then.
But my lord, order 16 rule 3, my lord,
You could have done you could have done that exercise by calling unlisted witness when your stage was there. You did not do it. You filed a
my lord,
petition.
after finishing other three PWs, my lord, I filed the petition.
Apparently no. Apparently no. This was not filed when the PW3 was not examined. This is after closure of PW3 that you have filed this petition.
Yes.
So if the witness number 3 is closed, the court will fix naturally the next date for PWs. It will not be for PWs. So you can't
My
exercise.
lord, if it is for PW, then my lord, no grievance. But my lord, since my lord, chance
Then
was
we
not
don't
given.
find anything wrong in the order.
My lord, I am relying only one paragraph of a judgment, my lord.
Yes.
That is become. This is paragraph 30. 29 provisions are quoted. In 29, my lord, provisions of CPC quoted.
Yes. What do you want us to infer from this? What do you want us to infer from this? With this citation, what do you want to prove?
My lord. I want to prove, my lord, even if the witness is not listed, then court has the discretion under rule 3 of order 16. My lord, it can be
That
examined.
it did not exercise. Had that been exercised, there would have been no question. We did not exercise that.
Basically, I rely on paragraph 31 and 32.
It would not apply in this case. In your case, that would not apply.
My lord, rule 3 says so, my lord, it is quoted in paragraph 29. The court may, for the reason to be recorded, permit a party to call, whether by summoning through court or otherwise, any witness other than those whose name appear in the list of refer in sub-rule 1. If such party shows sufficient cause for the omission to mention the name of such witness in the list, in the said list. The power is there, my lord. And my lord, in counterclaim, intermittently, my lord, the plaintiff is in possession, my lord. Because, my lord, in the prayer, the counterclaim is, my lord, for recovery of possession. So I have to prove the possession by bringing this official witness. As my lord, this house of Indra was granted, and which is extending on the plot of land, 1 kata and 5 meter.
But Mr. S. Chauhan running counsel for the petitioner. Next paragraph. Here's from the materials available on record that the written statement from counterclaim was filed on 7/2/2020. However, there's no material on record to show the date on which the issues were settled and the time taken by the plaintiff to produce evidence in the case. It appears that certain orders were passed on 9/7/2025. By the Learned Trial Court, and the petitioner moved another petition on 12/8/2025 with a prayer to recall the order dated 9/7/2025. It appears that it appears that the petition filed on 12/8/2025 was also rejected. Thereafter, the petitioner has filed petition under section 151 CPC for recalling of the order dated 9/7/2025. It was rejected by order dated 23/3/2026. Something on record which was when the case was fixed for DWs. Learned counsel for the petitioner is for some time to file the necessary documents. So accordingly, matter stands adjourned today. List after how much time? How much time?
2 weeks.
List after 2 weeks.
Item 12.
May I please, Your Lordship? My lord, here the petitioner being the plaintiff has instituted a suit against the defendant who are the respondents, the opposite parties. My lord, the suit is for declaration of tenancy rights and permanent injunction.
You have filed this application against the refusal of injunction.
Interim injunction. I prayed for an interim injunction, ex parte ad interim injunction.
227 would not lie.
My lord,
227 would not lie.
my lord. Appeal will not lie on,
You search out, I am not there to advise you.
my lord.
Search, there are many friends who may assist you. You are dismissing it.
My lord, it may kindly not be dismissed. I will take instruction from my senior. It may not be dismissed. I'll,
Without jurisdiction.
my lord.
227 is without jurisdiction. We can't entertain this petition. Against
Right.
order of injunction, there is some appropriate remedy lies.
My lord, if the order would have been under order 39 rule 1 into final order,
Spend some time reading book.
my lord.
Spend some time. How much time did you read that? How much time did you spend today morning reading this provision of appeal? No.
No, my lord.
The clear made by Learned counsel for the petitioner, the matter stands adjourned as this application appears to the court to be without jurisdiction. List after
Next week, my lord.
week is paid for.
Honorable.
Yes, item 13.
Okay, we came here before, your lordship, with a limited prayer, lordship. Our right to cross-examine the PW1 stood closed.
How many adjournments you took? This,
Lordship, that was the day we have taken. However, Lordship, if may notice from the order sheet, they have taken 11 adjournments for the PW1 to come to the court after filing evidence, Lordship. On 11th day, he has appeared, and that day we have sought an adjournment, and that request was denied, Lordship, and the right to cross-examine stood closed. The impeach order,
that is the order dated 11/8.
11/8/25, Lordship.
But before
Page
that, how many
20.
adjournments you took?
Lordship, we also took some adjournments, but they have taken,
No, you forget about them. We are more concerned about you.
Lordship.
You are moving this forward.
We have also taken 3 to 4 adjournments, Lordship, but that time the PW was not present.
You see, that's your oral statement. Please show it from the record.
Lordship, please.
Please show it from the record.
Lordship, may I kindly produce page 35, order dated 9/1/25.
Just a moment. Which is the impugn order? Which order is the impugn order?
Lordship, impugn order is dated 11/8/25, page 2028.
Page
20, impugn order, Lordship.
for Mr.
A. Kakoti.
A. Gauhati, and counsel for the petitioner. Agreed by the order dated 11/8/2025. 11/8/25.
25, Lordship.
What has happened in between?
Right, Lordship, may kindly turn to page 20A. The case is next listed for filing of DWs. The DW has not been filed, and the case is on the same stage, Lordship.
Then we can't encourage. Now we are in May.
Lordship.
After 9 months, we are challenging that closure of PW1. So there was no urgency. I'm sorry.
Lordship, you have filed this in December 25, Lordship. 20 December 25, this CRP was filed, Lordship.
You see, we have noticed that. Then there was a defect, you did not correct it. It was returned. And thereafter it was rectified on 11/5/2026 and then listed.
Lordship.
Sorry.
Lordship, may kindly impose and cost and allow it, Lordship, if possible.
No, what cost? You are not there in the trial court, you are not there in this court to rectify the defects. You file it, keep it pending for 5 months. There is no urgency expressed.
Lordship, the matter is at the same stage, Lordship. My humble submission.
Delayed equity, that's what we have always been told.
I deeply about that, Lordship.
Sorry, we can't encourage that. In the process, we have students delayed for a year.
And deep apologies, Lordship.
It can't be allowed. This is the order dated 11/8/2025. Present revision was filed on 19/12/2020. On 19/12/2025, the matter remained defective. And therefore, and the same was rectified only on 11/5/2026. Therefore, the petitioner allowed the petition to remain effective for about 5 months. From the impugn order, it also appears that the petitioner side was not represented, though an adjournment petition was filed. Therefore, we direct the petitioner to produce certified copy of all orders that has been passed fallen from 11/8/2025 till date. Make clear that there is no stay operating in the present application. Next, for our list on how much time?
Certified copies, Lordship.
Certified copy of all orders after 11/8/2025.
Lordship, 2 weeks time.
List after 2 weeks is placed.
Right.
14.
Item 14.
My lord, I request for a small passover. Okay, Deepa?
And
Item 15.
Please, Your Lordship. Your Lordship, we have preferred this revision application challenging the order dated 25/2/2026, passed in title suit number 66 of 2023 by the Civil Judge Senior Division number 3, Kamrup Metro at Gauhati. What happened, my lord, was that we filed a suit, we along with the pro forma respondent, we filed a suit that is title suit number 66 of 2023, praying for a decree of declaration, cancellation of agreement for sale, and permanent injunction. The defendant number 1, that is the respondent number 1 in this revision application, he appeared, he filed a counterclaim, praying for specific performance of contract. Now, my lord, the suit and the counterclaim proceeded. We filed our list of witnesses. Inadvertently, the name of the plaintiff were not mentioned in that list of witnesses. And when the time came to adduce evidence, the PW3 adduced evidence as, the plaintiff number 3 adduced evidence as PW1. The defendant, they did not file any formal application, they verbally objected that the PW1 cannot be accepted because she is not a listed witness. Now, a hearing was conducted, and ultimately, the PW1 was not considered by the trial court. Evidence on affidavit of PW1.
but Mr.
D. Goswami, my lord.
Filling the order dated 25/2/2026, asked by the Honorable Civil Judge within bracket Senior Division, number 3, Kamrup Metro, Gauhati, in case number 66 of 2023, thereby refusing to accept the evidence on affidavit of PW3, sorry, the plaintiff number 3 as PW1, on the ground that she was not a listed witness. Present division of the final article 226 of 27 of the Constitution of India. Next one. As that order is not applicable on the section 115 of the CPC, this state provision in the cost title is struck off. The pastry shall duly make full. Next one. You should notice returnable long so and so. Commissioner shall take steps within 2 days for service of notice on the respondents by speed post with AD. The next returnable date, the further proceedings of article number 66 of 2023, pending before the learned civil judge within the Senior Division number 3, Kamrup Metro. State.
Further proceeding has been stayed, my lord. Correct.
Item
Yes, sir.
16.
But I pay for the petitioner. Here I come up before the court, refusal to pass an order
in an execution proceeding which arises from the execution of an interim award passed by the arbitrator. The interim award is a money award of 5.85 crores. Some part payments have been made, the balance. I must indicate here, the award was passed in Calcutta. The respondents are the registered office of the company is in Calcutta, but they have a property within the jurisdiction of this court. So I moved the commercial court, the commercial court here, Kamrup Commercial Court. I moved the Kamrup Commercial Court. The order, it was less than 2 years, so I did not serve them a notice. I moved it ex parte. Now, the interim order, it records, the impugned order. The impugned order, I only pressed for a special officer or a receiver to go and make an inventory of the property which is within the jurisdiction. What is the status of the property?
There's an arbitration award.
Yes, it's an arbitration award. The arbitration award you will find in supplementary affidavit because I've missed some pages.
It's additional supplementary.
What is the date of the arbitration award?
The date is 6th of May 25. 6th May 2025. The award has been passed by the former judge of the Calcutta High Court, Madam.
How,
Alok
that was passed during the pendency of the, what you call, this IBC proceeding?
No, there is no IBC. No, we have annexed, there is no section 14 moratorium passed. We have annexed those orders that IBC proceedings are also continuing. It is not that section 14 of moratorium has come in. We have annexed those to show the precarious financial condition of the judgmentator, because they have taken a loan from Yes Bank and other creditors also there. So those orders are annexed to show to the court that the financial position is precarious. That is the urgency. We need a protection order. Otherwise, my award becomes a paper decree. That is the only purpose. No section 14 moratorium passed. So no IBC final decree. But the interim award, the order, we must have got it on the page. 409, which is additional affidavit. The interim award is 6th of May 2025. The operative portion, you will find at the internal page 12 of the order. 421, just help me with the page number. 421, this records that the claimant is entitled, his malady is at page 421. Yes, entitled to a sum of rupees 5.85 crores from the respondent number 1 towards its dues on account of the principal amount due. In view of the finding in the order, the respondent number 2 under section 16, no interim order is passed against respondent number 2. I'm not concerned with that. All other points are left open, last paragraph. Therefore, on the findings recorded herein above, an interim award is passed, hereby directing the respondent number 1 to pay the claimant a sum of rupees 5.85 crores towards the principal due forthwith. This award was passed at Calcutta on the 6th of May 2025. Now, two things I also should indicate, Manoj. There have been made some part payments, which you will find at page 22 of the application. Out of 5.85, payment has come around 1.43. Page 22 of the application. Page 22 of the application, where you have said para CC.
Page 94 of the page. Page 94 of the page.
No, that is the petition for the trial court. Even before the Honorable Single Judge, trial court, we have said the same thing. Now, the payment which I have indicated, the final payment which has come is 1.43, which is at page
transferred here.
Yes. So for the transfer is concerned, Manoj, I say, Manoj, there is no transfer required, because even the same question was put to me, Manoj, that there is no transfer required because we are covered under this judgment of the Honorable Supreme Court in Sundaram Finance, which says that in an arbitration, had it been a decree of a civil court, it has to be transferred under Order 21. This being a arbitral proceeding and the award passed.
Why have you preferred this execution here?
Yes, the property will kindly come to the schedule which I have annexed, which at page, the schedule, I have given a schedule here, the property is here. So I cannot execute the page 302, which is now, I think 369. Even the schedule is in the petition also. Paragraph, page 23, paragraph E. That is,
So, where is the document regarding the schedule?
yes. So this is the property in Patharkwadi near Sandgaon Traffic Police Station. Yes. No, the schedule I have mentioned in page 23. Page 23 of the 227 petition, paragraph EE. Page 23, the reason why this court, why Gauhati, is the property is in Gauhati. The property is in Gauhati, and document in support of this, by merely me saying won't do it, because I say page 368. Yes, now page, so document in support of this is at page 368 page. This is from the website of the respondent company's website, it says that 368, 369. So this is the property and the address is at 370.
368.
Yes, 368 onwards. Yes, this is the part of the entire execution petition we have filed before the commercial court. 370 is the address, which not my mayor saying, is the respondent's document which shows that this property, they own this property. Now, I also understand one of the reasons why the commercial court did not pass the order is that it records that it's a huge multi-storied building. Third-party interest must have been created. So an order can affect third parties. To that, I say, even before the commercial court, I only pressed a special officer or a receiver to go and make an inventory. And an injunction not to create further third-party interest. If further interests are created, I am remediless. So page 370 is the address of the property, and it gives further details with regard to particulars of the properties and other things.
How do you find out from page 368 that who is the owner of this property? From 368 onwards.
Yes. It records the name in the top. You see the name of the respondent once. The name of the respondent which is in the interim award.
Page number?
Page number, there is the new supplementary affidavit, the page number 409. But you will see the name of the respondent, Ideal Real Estate Private Limited. So that's the main company of the group.
But this building which you are showing in the photograph is owned by them. How do we, or they are the builder, how do we know that?
Because they are the builders of the property, so they have an interest in the property.
Which is the document to show that?
That document which is available, but that's the reason. It is 368. At 368 in the bottom, what you will find.
Ideal.
Yes, that's even in the website, what you will see the Ideal.
It's only ideal. Ideal does not mean that it would be the respondent.
Is the Ideal group which is given in the website. So you will see 360, 370 in the top premier residential apartment in Gauhati, Ideal group. What do you see? These things can be ascertained, which I was pressing before the commercial court also, before this court also. If a special officer goes, and to ascertain what is the status of the property and who is the owner of the property, because he is the developer, which is evident from what documents available in the website, that he is the developer of the property. He also sees at 374 that brochures and other things.
Developer of a property would not mean that he is the beneficial owner of the property.
May not be. Yes, there's a ratio. 60, 70, 30, 40, with
Whatever be.
whatever maybe. It can be a ratio.
Today it is a flat of X, tomorrow it may be your property, we don't know.
Yes, it can be. Yes, it can
Property
be.
taken
So the
over.
landowner can be different, the developer can be different,
And the,
and the ultimate flat owner is different. 100%, it can be. That's exactly what happens. Now to ascertain that, how do a person ascertain this? Because the respondents in the meantime, the moment they know, that is the reason, Mala, I cannot ask for attachment today. I cannot ask, I know. In a execution of a money decree, attachment falls. Section 51. Section 51, attachment falls.
where is your application before this court for appointment of receiver?
Annexure 2. No, the prayers, annexure 2. No, the annex, before this court, Malad, which is the prayers at page 49.
No, before the execution.
Oh, before the trial court, just tell me the page.
The executing court.
I just show you. Annexure 2, page number, really. I'll just show you, Lordship. There was we had a separate application also before the page 73 onwards. Yes. Yes, urgency. Page 73 onwards, yes. Page 73 onwards is part of the commercial courts application. The mode of assistance, which is prayer C. Well, prayer C, only the first portion, because I know the predicament was falling from the court that the land is owned by different, the developer is different, the flat bar is different. That's commerce, how it works. So, my lord, I say the inventory be done so that my award is protected. I have a specific pleading that there is no stay. Some payments have been made, and if they sell away the property in them, I will come back. If they give them notice, we'll come back. I'm not asking for attachment at all. A special officer or receiver to make an inventory of what is the status of the property and how many flats are sold, unsold, and those. We are asking for sale, nor asking for attachment, which are the other reliefs I'll press later. Prayer E. No, prayer E I am not asking as on date. Prayer not also prayer D. It's only the the inventory. Prayer C. So that is the only thing that I say, my lordship, that the Sundaram Finance has given the award holder the liberty that he did not, but he transferred. You can straight away go and file before the jurisdictional court where the property is there.
But, sir, your name?
Aniruddha Mitra.
Mr. E. Mitra, and let's answer to the petitioner. By filing this application under Article 227 of the Constitution of India, the petitioner projects itself to be the award holder in connection with arbitral award. Where is that?
Well, the arbitral
Award?
409. Page 409. Additional affidavit, page 409. Page onwards, yes.
This is only interim award.
Yes, is it. So the principal amount is awarded, the rest remains for, it records the.
The holder of the interim award
That we can always execute.
dated 6/5/2025, passed by the London Arbitral Tribunal in connection with arbitration proceeding bearing capital GA-COM-1/2024. Between the petitioner and the respondent number one.
Respondent number one. one respondent.
So it is submitted that the execution proceedings was initially filed before before the court at Calcutta. Where is that page?
No, the Lordship wants to know the impugned order.
Filed in Calcutta.
Oh, the Calcutta page, man, sir. Calcutta page, execution in High Court. Is at page 293. The impugned order is in a different page, man.
No, it's okay.
Sorry. Hmm. 293, so it is the Calcutta proceeding.
It was filed before the Calcutta High Court.
Yes, it is also filed before the Calcutta High Court.
Filed before the
Because the
commercial division of Calcutta High Court.
the civil court, the civil procedure courts give me that liberty, man.
Okay. As the property of Schedule A is projected to be situated in Gauhati, the execution of that part of the interim, for that part of the property, the proceedings was transferred. It is not transferred yet.
No, it is not transferred, man. It was filed.
It was filed.
Filed, yes. Sorry.
It was
Yes.
filed
Before the commission.
before the learned civil judge, in bracket senior division, that is number 2,
Kamrup Metro.
Kamrup Metro Guwahati. It was registered as money execution within bracket RPR. It was case number 32 of 2026.
Obliged.
It is submitted that the petitioners have made a prayer before the learned executing court for appointment of a receiver in respect of the property described in Schedule A of the said application, power to make inventory and to submit a report. The said application was rejected. Where is the order? Which page is that order?
The page 57 is the. That order was not granted in my favor. It was
The order dated
refused to pass.
7/4/2026.
Yeah, refused this. Yeah, refused to pass.
Accordingly, it said order dated 7/4/2026.
Yes.
Passed by the learned civil judge, senior division number 2, Kamrup Metro Guwahati, in money execution within bracket R, case number 52 of 2026, has been essayed. In this application filed under Article 227 of the Constitution of India. Will it not be an appealable order under Order 43 Rule 1 S?
The impugned order, my lord.
Yes, refusal to grant an
The
order of receivable.
order 21.
Order 43.
No, it is not appealable. It is not appealable. That is the reason at 227. It is not appealable because there is CPC.
It is
Yes. Order 43.
Order 43 Rule 1S.
No, because in an execution, the power to appointment comes under section 51. It is not 39 1 and 2 or a receiver. It is not order 40S. It is not order 39 1 and 2 or a receiver in a normal proceeding. And in the commercial, it is all the same. So it is not. It is this power.
Under exhibition. Under
Yes.
exhibition.
Yes. This
21.
power is under section 51.
51.
Had it been a normal suit, then order 39, 40 receivers, then appealable. What happened in the other matter, I was there, so the other matter is appealable. So it is not appealable here.
The notice returnable on, give a date after 4 weeks, returnable on so and so. The petitioner shall take steps within 2 days for service of notice on the respondent by speed post to PD. So the counsel on record is for the petitioner is permitted to collect the postal district number and submit postal track report prior to the next date of listing. This constitutes.
Lordship is not passing a order of receiver.
It is not would amount to allow your entire petition. It would amount to allow your entire petition.
No, only an inventory be done, my lord.
That has to be with the, once it is rejected.
If only an inventory could have, I'm not asking a injunction or anything.
No, but that would amount to allow your application, that the proceeding before the
No,
executing court.
allowing the application is the payment of money, it's the execution. Had it been an execution, then a payment of money comes in.
You said that one of your prayers was that.
Yes, before the.
This will be family remedy.
So we are not asking for the payment of money, we are not asking for. It's only pressing that if a special officer can go or a receiver can go and make an inventory.
You can, if you are also permitted, if you want, you can pass on order, bring on record email address through which you can serve it to them. We can expedite.
That's there in the website also, their email address.
No, that we don't know, but unless it is brought on record, we can't allow you to give service on that.
So email address is there because the MCA portal to
No, in your costed it is not there.
No, in the costed.
You can bring it on record and we'll permit you to serve by email. If you
That
want.
we can serve by speed post, will take 2-3 days time.
If you want a shorter date, we can give.
No, Lordship is giving us after the vacation, I believe that. The courts are reopening in 13th of July, it's reopening because the next week won't be possible, that the last week. So any day, 17th of July or any Friday, that anything.
17th of July.
17th of July. Yes.
Okay. 17th of July. And Mr. Mehta, there is another reason to just tell you another, the normal practice we follow here.
Right.
Is not the nature of interim you have paid for. You have to spell it out. Actually, what interim order you desire.
No, in the appeal, I have spelled it out.
You only said in terms of above.
No. Oh, no. But she will see the interim measures if that's
In terms
the.
of above. That's what you have said.
No, oh, okay, that's the, Lordship, you see the prayers, the second prayer, my lord.
So we understand that, but the interim, the page 51, the interim prayer is interim orders in terms of above.
Okay.
That could be anything.
That's the, we do it, that's
So
sorry.
we understand, that's why we are telling you, otherwise I would not have told you.
Oh, that's.
Since you are,
No, but this, the second prayer, page 51 is also there, but that becomes not a ad interim, that's not an interim. That's not an interim.
You can rectify those again, because next date also you'll have to, you may face some difficulty.
Or I can file a separate application for this.
For inclusion of that.
Yes, so she will kindly grant me that liberty. When my advocate on record, she's from this court only, but she will take care of it.
Before the last speaker said, on the prayer made by the counsel for the petition, the liberty is granted to file an application for inclusion of certain pairs in the amendment of the petition to include some pairs, entry pairs.
Obliged.
For motion, item 51.
Lordship, I have collected the photograph. And it is correct, that is not a Prem Bhavan, it is a Pran Bhavan. Lordship, that is what I am collecting. But Lordship, I have gone through the memo of appeal. In the memo of appeal, it was filed as a Prem Bhavan. And they appeared, nobody has.
Not that, but
Lordship.
the problem is with regard to the provisional notice.
So that is to be, cause that is to be amended, Your Lordship.
Do it. Do it, whatever has happened has happened.
Right, Lordship.
But it was just an intuition. Okay. Mr. R.K. Bhuyan, Senior Counsel, assisted by Mr. S. Singh, Learned Counsel for the petitioner, submits that he is obtained the photographs of the concerned building and as the name of the building is wrongly spelled in the first item, comma. Is erroneous, perhaps. Having noted that the error is only of the spelling of the name of building, comma, the court permits the General Inspecting Council to make necessary correction in the constitution by hand and there is signature before the EOJ. CRP key section 1, CRP key section 1, civil division section. The EOJ, civil division section shall do and consequent to amendment, the CS, the data in the CS system be also updated and thereafter the matter be listed again in the motion part. If you permit you to do it,
Lordship, because Lordship, they have already filed an execution case.
you do it on the Monday, you send it, then return the record today. Tomorrow you can do it.
Lordship. Lovely.
Time being item 14.
Mr. Bhuyan? Mr. Bhuyan? You can do it by, you want to do it by tomorrow?
Tomorrow. You can, Lordship, one thing, my client is in Chennai, during medical.
No, we are permitting you to do it. The collection.
Tomorrow, right? Tomorrow.
We'll do it by tomorrow.
Tomorrow, sir.
This is the matter again on 18/5/2026.
May I please, Lordship? My lord, in this case, my lord, we are agreed by an order dated, my lord, 25/2/26 at annexure 11, page 68, my lord. Okay, no, sir. May I please, my lord, in this case, my lord,
Yes.
In this case, my lord, we are agreed by an order date 25 to 26. Whereby, my lord, cross-examination of the remaining witnesses was closed, my lord. This is a case for ejectment of tenant, my lord. And my lord,
How many adjournments did you take?
my lord,
From the stage of PWs, how many adjournment did you take to present your witnesses for cross-examination?
I'm coming to that, my lord. Actually, my lord, cross-examination of PW1 was completed. Thereafter, what happened was that, my lord, there were four defendants. One of the defendants died, my lord. So, my lord, we were required to, my lord, inflict the, substitute the, my lord, the legal hair of the said defendant, my lord. But that was not done. But thereafter, my lord, after some days, my lord,
See, what we have, we may be wrong because I don't read it so thoroughly. If I remember it correctly, the case is fixed for examination and cross-examination of witnesses since 2022.
I'm that is why I'm coming, my lord. Although it was fixed for cross-examination, but, my lord, when DW1 died, my lord,
When did he die?
my lord, I'm coming. Para 6, my lord, 4/10/23, my lord. The defendant side informed the court that Nirmala still died, my lord, on 4/10/23, my lord.
Yes.
4/10/23. Page number, my lord, 45, my lord.
Yes, yes, please continue.
Page number 45. So, my lord, Gitanjali Roy was to be made a party, my lord, substitute, but that was not done by the concerned council, my lord. That thereafter, my lord, a petition was filed, my lord, under order 22, my lord, for substituting the legal hair, my lord. That your lordship will find that page number 49, my lord. And the case was fixed for objection hearing.
You are the plaintiff.
Yes, my lord.
You were directed to take steps.
Yes, my lord.
The court records at in order dated substitute the death is 4/10/2023. There's a court order of 29/7/2025 that the plaintiff has not taken steps on the substitute defendants.
That is true, my lord. That is the mistake, my lord, done by the council, my lord. So
After that, somehow you could serve notice. Then the court says that please go to the commissioner, cooperate with the commissioner, do the examination of witnesses. And
one
what date-
commissioner,
dates I don't remember.
was actually changed, my lord. My lord, here case is that, my lord, we are a plaintiff, my lord. We will suffer, my lord. The defendant has nothing to
You will
suffer,
not
my lord.
suffer. It is the judicial officer who is suffering. Because we issue show cause to the judicial officer, not to you.
Because, my
That's
lord,
why it is taking delay in the closure of PWs.
there was miscommunication between the, my lord, client and the, my lord, advocate, concerned advocate, my lord.
No. We are not that soft on the judicial officers when we take administrative steps.
My lord, we file a petition, my lord, for recalling the said order, my lord, but that was not allowed also.
Correct.
It is not only for that we have taken time, my lord, but the case proceeded, my lord, due to various other reasons, my lord.
You see, how much time does it take to serve notice on a substituted defendant?
Now, substituted defendant,
You
my
took
lord,
more than almost 3 years to do it.
yes,
2 years to do it.
the address was actually not provided to the concerned, my lord, to us, and thereafter, my lord, we could not serve the notice, my lord. And there was some mistake on part of the concerned council, my lord. On the council also did not appear on some dates, my lord. The report will show, my lord. So, on 29/7/25, my lord, page 63, the council did not take, was absent without steps, my lord. And again on page 64, my lord, the council for our council was also absent, my lord.
You see, once the provision of order 17(1) is exhausted, more than 3 adjournments at this stage, what can we do?
No, actually last Sunday we provided, my lord, so that, my lord, they can Because for credibility of the evidence, my lord, their evidence is necessary, my lord. But at least one chance will be given, my lord. That is only our prayer, my lord. A fixed date will be given, my lord, will appear on that day. And if it is, if they do not appear, my lord, then evidence may be. No, my lord. If your lordship goes to the order, it will see that some mistake was there on the part of the counsel, engaged counsel, my lord, who did not conducted that case properly, my lord. During the pendency, my lord, one advocate commissioner will also change, my lord.
Not impressed. See, the more we read in this matter, the more confused we become. This is a suit of 2013.
Yes, my lord, that is true, my lord.
When the case came for PW, then you say, I amend the plaint. You were allowed to amend the plaint in 2014. You amended the plaint and thereafter again the proceedings continued. After 9 years, after 8 years, you file your evidence.
No, evidence was filed long back, man.
2022,
Yes, ma'am. Evidence was filed.
22, it was filed long back.
Yes, long back.
The person died in 2023. From 22 to 23, you did not produce your witnesses for cross-examination.
Now, in 22, one cross-examination of PW1 was completed. Order shows.
After that, what happened?
On my lord, 2/4/2022, my lord.
Okay, your case has been pending for 12 years. Now it will be over. And it is an ejectment suit.
Yeah, we will suffer, my lord, surely.
Ejectment suit of the ejectment
It is of tenant, my lord.
of tenant.
Yes, my lord.
So that is not sub res judicata. You find another ground to challenge that to again try to evict these people.
Because my
Yes,
lord, then the
With
proceeding
so much of delay, we are not impressed.
that, my lord, only one chance is given, my lord.
Okay. Had your conduct been always also accepted it? Every time the court strikes an order that please cooperate to your fire, you take steps
That is
for
true, my lord.
certain that you don't take steps.
That has been, that is the mistake, my lord. But now, my lord, if one chance is given, my lord, only a single date, that will be enough for us, my lord. Because otherwise we will suffer, my lord, because they are in possession of our
Your
house.
default is solved for. It's not one default in one stage. Every stage there is a default.
Yes, my lord, default there is in default in, my lord, making the, then substituting the, my lord, legal hire also. Then they did not send the notice also, my lord.
You would not.
So, my lord, it is actually a fault by the, my lord.
But you see, when you are filing a suit, you know that if you default, these things will happen. Very easy to say that the lawyer did the mistake. You don't show your diligence that you were contacting the lawyer. That statement is not there that we were contacting the lawyer every time and we were given false messages and information about the suit. That is not your case. It's in the long back they took a defense in the written statement. Then you realize and then file this application for amendment. Every time it is the court which has to find out your issues and then you, first of all, one person died. His legal heirs were brought in.
No, not
Then the second one died. and then again, steps was not taken. The original defendant died.
Yes, sir.
After the original defendant died, you made a prayer and the other three were substituted. After that, somebody else died. And then it took you 2 years to substitute it and then make service. If somebody is your tenant, it can be served immediately down on the same day when the notice is issued. Before you make the delay and then again with the substitution application, condemnation application, the condemnation application, then all those hearing takes place.
Yes, sir.
So you are comfortable with it. Sorry, we are not interested. But I for the petitioners. Next, by filing this application under Article 227 of the Constitution of India, the petitioners who are the plaintiffs in TS 53 of 2013 have assailed the order dated 25 to 2026, passed by the learned civil judge in the Union Division, number 1, Dibrugarh, by the said impugn order, the learned trial court rejected petition number 1605 of the 26 for adjournment, and having noticed that the case was initially in the evidence stage since 34 2014, and out of 5 PWs, only 1 PW was cross-examined. The said petition was rejected, and the evidence of PW2 to PW5 was ordered not to be considered for want of cross-examination. And case was fixed on 26/3/2026 for defendant's evidence. Witnesses. For the petitioners have submitted that this is the reference to the said order dated 25 to 2026 was not recalled or set aside from the petitioners who are the landlords and want to have the defendants evicted and respondents evicted for irreparable loss and injury. Next. This is notice from the impugn order dated 25 to 2026 that the case was fixed for case is ready. So since 34/2014, the case is pending for PW evidence. And the learned trial court has recorded that uncountable adjournments have been taken by the petitioners for producing their witnesses for cross-examination. Court is of the considered opinion that as the adjournments permissible under order 17 to 1 of the Civil Procedure Code has already been exhausted, committing more than 3 adjournments at the stage of PW. cannot be said that the order dated 25 to 2026 is bad or perverse on any count. Therefore, come in excess of jurisdiction on Article 227 of the Constitution of India, the court would be slow in interfering with the order by which PW examination of cross-examination of PW number 2 and 5 closed by order dated 25 to 2026. The delay on part of the petitioner is evident at all stages of the suit. So the defendant's right at the stage of cross-examination of PW. So 2 years time for the petitioners to take appropriate steps and to serve notice on the submitted defendants. So in this regard, we mentioned that though the defendants by filing petition on 4/10/2023 informed about the death of one of the defendants and disclosed the names of the legal representatives by producing the legal health certificate. Application for substitution was filed long after expiry of the limitation prescribed, filing a petition for substitution and putting aside of witness. Notice could be served. It is from the record there, which a lot of default in taking steps for service of notice on the subsidiary defendants. And only after the Senate trial court passed an order on 6/9/2025 that if steps are not taken within 7 days, the suit could be dismissed against the subsidiary defendants. Appropriate steps were taken and eventually oh, your suit was dismissed against defendant number 1.
Yes, madam.
On the order dated 12/11/2025, ultimately the suit was dismissed against defendant number 1. Therefore, the case was fixed for cross-examination of PWs on 19/12/2025. And after adjournments being taken, ultimately the order was passed on 25 to 2026. Therefore, if interference is made to the That order dated. We said thinking orders dated. '25 to 2026. To render OTOs the provision of order 1701 of the CPC, which limits adjournment to not item C at this stage of hearing. So we do, the court does not find any merit in the petition, the petition is dismissed. And the motion stays without issuance of notice on the respondents.
Grant.
Upgraded item 56 for orders. Upgraded item 57 for hearing.
My lord, this is the EV5 building construction.
It's only that repair without the in your absence, that can be ordered. Repairs in your absence can be ordered.
In respect of minor repairs,
So we'll record your objection. We'll record your objection.
only in respect of repairing, not only in respect of repairing, not the other erection or.
No, definitely not.
That may be clear.
Repair, painting or something.
That may be clear. That is already there in the first part. That's already there in the first part of the technique.
Where he shows that.
Now, there are two parts in the order. The defendant has no right to make addition,
Alteration, modification,
demolition of the suit house.
So may allow to do hearing in the presence of plaintiffs. That we can omit.
That in presence of now. Plaintiff.
Yes, Mr. Saiwala.
Hello? Yes.
The absence can be removed, that's all. One, we cannot do it because then it changes the issue totally, and 5 becomes operative. One is okay, 2 interfere. Third, Mr. G. and Sarada, in your counsel. Assisted by Mr. Sodhi and for the appellants. Also had Mr. D. Chaudhary, and counsel agreeing for all the respondents.
One and two.
One and two. Three and four are already struck off.
Already stuck. My order is 17 to 12.
Appeal under section 100 of the CPC is directed against the appellate judgment and judgment order and decree dated 2010, passed by the learned district judge, Tinsukia, in TSTA number 6 of the 2009, partly allowing the appeal by modifying the judgment and decree dated 2/9/2009, passed by the learned civil judge, Tinsukia, in TS number 53 of 2006, with the 2+ decree. The respondent number the respondent numbers 1 and 2 were the plaintiffs in TS number 53 of 2006. The case of the respondents is that the appellant as defendant number 1 was conducted in the suit premises as a permissive occupier purportedly on a verbal tenancy agreement that no addition, alteration, modification, demolition, repairing works, etc. should be carried out in the suit premises, and that the appellant would vacate the suit premises as and when the same was required. The on the allegation that contrary to the agreement, Some building materials were collected by the appellants and attempt was made for continuing permanent construction of the suit land. The respondents filed the suit for declaration that the appellants herein had no right to make any addition, alteration, or modification, or demolition, etc., or any other repairing works in the suit premises, for permanent injunction to the same effect, including prayer for ad interim injunction as prayed for. It would be pertinent to mention that the suit premises is covered by holding number 103 of ward number 5 of Dunduma, measuring about 2,000 square feet over the land covered by periodic patta number 56 under tag number 1322, which is more fully described in the schedule to be plain. The learned, next part, the learned civil judge, Tinsukia, by judgment order and decree dated 2/9/2009, decreed the suit by declaring that the appellant has no right to make any addition, alteration, modification, demolition, etc., or carry out any repair works in the suit premises. Accordingly, permanent injunction to that effect was granted. It may be mentioned that in order to decide the suit, four issues were framed by the learned trial court. Page 30, para 9, 1, 2, 3, 4. Put a flag. In support of the pleadings, the respondents as plaintiffs have respondents as plaintiffs examined two PWs and exhibited 5 documents as exhibit 1 to 5, and the appellant side, examined 2 witnesses and exhibited documents as exhibit A to exhibit N. Next. As indicated above, the aggrieved petitioner has filed. Sorry, appellant has filed title appeal number 6 of 2009. That appellant is only one. Appellant and respondents plaintiffs are 2. File title appeal number 6 of 2009. And by the appellate judgment order and decree dated 20/12/2010, while maintaining the decree against the appellant, declaring that the appellant has no right to make addition, alteration, modification, demolition, etc. of the suit house was maintained. However, while granting the decree for allowing the repair of the suit house to be done, it was made conditional that the repairing of the suit house was allowed without changing the basic nature, character, and structure of the same, with the rider that the same be done in the presence of the respondents or the representatives of the agents, etc. Next. Assuming the first complete order, the learned senior counsel for the appellants has submitted that admittedly the suit was under section 5 of the Non-Agricultural Areas Urban Areas Tenancy Act.
Yes, no, Assam.
And therefore, as no eviction from the suit premises was ordered, the fact that the petitioner, the petitioner must remain in the suit house had attained finality. Accordingly, it is stated that as the house was not constructed by the respondents, as there was no prayer for recovery of this of the house. The presumption would be that the house was constructed by the appellant, and therefore, to maintain it in a livable condition, the repairs of this house without changing the basic nature, character, and structure was required. And accordingly, it is submitted that the presence of the appellants or the representative of the agents, etc., was a condition which is unwarranted in the first appellate decree. Next. The learned counsel for the respondents has vehemently objected to the case made in connection with this appeal. It is stated that it would be very necessary for the respondents to be present when the repairs were carried out, so that they would know that the repairing of the suit house was being done without changing the basic nature or character or structure. Submitted that as the right of the respondent remain as the owner of this land, they have every right to verify as to what nature of constructions are being carried out in this premise. Next. The issue raised in this second appeal appears to be restricted only to the clause made in paragraph 40 within bracket 2 of the appellate order, as to whether the presence and the only issue revolves around the question as to whether the presence of the respondents, the litigants, or the representatives of the agents, etc., are required and the usual repairing of the house, make it returnable and livable, necessary. Next. The substantive question of law on which this appeal was admitted for hearing, order dated 17/2/2012, is reproduced below. Order sheet dated 17/2/2012. Next one. Of the materials available on record. As there is no clear in the plain that the tenancy was in respect of the house, and as by the judgment order and decree passed in these two, and in the first appellate proceedings, that the tenancy in respect of the land was maintained. The court is of the considered opinion that the appellants herein have been able to demonstrate that the tenancy was not in respect of the house. There's nothing on record in the evidence of the witnesses examined that the house was not built by the appellants. And in view of the fact that no eviction or right over the house has been gained by the respondents, that plaintiffs, or that no issue arises as to who will be the owner of the house. Next. Nonetheless, as the tenancy is in respect of the land which is governed by the provisions of Assam Non-Agricultural Areas Tenancy Act.
Urban areas, known as urban areas.
Urban Area Tenancy Act for 1970. So
1950,
50 years.
71, 1950,
50.
55.
The court is of the opinion that the respondents would be willing to cite to see that in the name of repair of the house, the basic structure of the house is not changed or dismantled. And substitute new construction. Therefore, they have a right to examine only that. However, if there's a decree allowing the repairs to be done only in the presence of the respondents, that plaintiffs, or their representatives of the agents, etc. I would interfere with the right to the appellants over the right to keep the house in a repaired manner for making it in a livable condition. So therefore, the characters contained in paragraph 40 within bracket 2 of the appellate first appellate order, restraining the repairs to be carried out, but in the presence of the respondents, that plaintiffs, the representative from an agency, etc. Not found susceptible in the view of the nature of care made in the plaint and evidence tender. As the right of the respondent, the plaintiff is duly protected by the by the judgment and decree passed by the learned trial court, and also affirmed by the learned first appellate court in paragraph 40 within bracket 1 of the appellate judgment of the decree, holding that the defendant has no right to make addition, alteration, modification, and promotion, etc. of the suit house during the repair of the suit house, including painting, etc. Comes within the meaning of repair and would not be included in the first part of the decree relating to addition, alteration, modification of the demolition, etc. They're part of the separate judgment and judgment decree and order as contained in paragraph 2 of paragraph 40 of the first separate judgment order and decree 2012-2010 passed by the learned district judge from Atisaki and title appeal number 6 of 2009. Hereby interfered with Davis Bonafide as follows. The defendant may be allowed to the repairing of the suit house without changing the basic nature of a character, size, and structure as indicated in paragraph 40 within bracket 1 of the first appellate order, judgment order and decree. However, it would not be necessary for the repairs to be carried out only in the presence of the plaintiffs or their representatives, the agents, etc. It is further clarified that in the guise of repairs, the appellants that defendants would not have a right to infringe the decree as ordered in subparagraph 1 of paragraph 40. To that extent, the respondents that plaintiffs are protected. According to the certain question of law answered by ruling that though the tenancy was in respect of the land and not respect of the house, but as the tenancy is governed under the provisions of Assam Non-Agricultural Area Urban Areas Tenancy Act, although the appellants have a right over the house, but the defendants as plaintiffs have a right to examine that in the names of repairs, the structure of the house is directed in subparagraph 1 of paragraph 40 of the first appellate judgment and decree not altered. Thus, the appellants as defendants have a right to repair the house as per in view of the provisions contained in subsection 1 of section 5 of the Assam Agriculture non-agriculture areas, urban areas can say 1955. Appeal funds are allowed to the extent as indicated above. The registry shall drop a formal decree and make it a part of record. I think we have left out passing orders in second appeal after quite a long time. That's why I'm asking. Anything left out? Anything left out is
Left off.
did I leave out anything?
Oh,
No. Your book.
huh? No. That's it.
Upgraded item 56.
May I please have the lordship? My lord, a second appeal, my lord, came to be closed pursuant to a prayer.
Oh, just,
My lord,
I've
may be
noticed
pleased to.
just a moment. I've noticed Mr. Podar here.
My-
Mr. Podar, after the court rises, please meet us in the chamber. Yes.
My lord, the page 14 is the order by which, my lord, the second appeal was, what was withdrawn, closed on withdrawal, my lord. My lord, page 15, my lord, Mr. So-and-so, the learned counsel, appearing on behalf of the appellant, submit that the appellant would not like to proceed with the instant appeal. Taking into account the above, the instant appeal stand closed on withdrawal. My lord, my instruction, my lord, is that there was no any such communication had been made with the previous counsel, my lord. Some bona fide mistakes could have happened, my lord, due to this situation, my lord. Now, my lord, we were with the impression, my lord, that the second appeal is pending before this honorable court. But, my lord, when the execution case 16 of 2025 had been initiated, then only, my lord, we could learn regarding this order, my lord. So that's why, my lord, now we have referred this miscase, my lord, with the prayer, my lord, that the appeal may kindly be restored. Otherwise, my lord, all rights.
You see, perhaps there was some good reason for the for this order to be passed
My lord,
and the withdrawal.
my
You
lord.
see, there is somewhere in the first appellate order that you admitted to the share.
That
Once
is
you
the
admit
order.
to the share, then how will a suit for partition and the appeal would be maintainable?
My lord, my lord, the first appellate order, my lord, although there
So
are.
first of all, am I right in saying so?
My lord, my lord,
Because I don't read it so thoroughly, so I
Right.
may tend to mix up things.
my lord,
In this case, am I right? First,
my lord,
there's an admission, okay.
my lord.
So if there's an admission, how would the appeal be maintainable? That's the query.
No, my lord, if my lord restores the second appeal, my lord, then we will try to satisfy my lordship's, my lord, that what was the exact situation was there, my lord.
You see,
My lord,
can I say something in a lighter note?
my lord,
I always remember my college days when I have to go to a small tea shop and have my tea.
my lord,
I would look at I would close the name of the items first, read the price, and then look what should I eat.
my lord.
That was my way of leading my life in my school college days.
My lord.
That is, I am still retaining some of it. So therefore, if you show us that you have some merit, then perhaps we can reopen it. Because if the shares are
Agreed upon, my lord.
agreed upon,
My lord, my lord.
then would a appeal on admission be what has been admitted?
My lord, my lord. I
Appeal would
can
be
understand.
maintainable. That's the issue.
Once it has been agreed in the first appellate order, my lord. But my lord, the issue of my lord withdrawal was not at all been instructed by the parties, my lord. That's
No,
the issue.
parties will not tell you the law.
My lord,
It is for the council to understand the law and then tell us that whether you want to proceed with that or not.
my lord. My lord, I have a very limited knowledge on these subjects, my lord, of CPC.
No,
my
be
lord, but
prepared because-
my lord, I will try to satisfy my lord, my lord.
If you can make out a case that yes,
My
despite
lord.
this, you still can maintain a second appeal, then we'll issue a notice here.
My lord. And my lord can fix it on coming Tuesday, my lord, next week.
Tuesday, okay.
Some urgency is there because
Tuesday.
of this, my lord,
Can
execution.
we fix it on Monday, because Tuesday we have few matters
Yes,
already
yes,
fixed.
my lord. I can,
It'll take some hearing time.
my lord.
18th is Monday.
Yes, my lord.
Um, uh, It appears from the contents of the first appellate judgment, order and decree that the learned first appellate court has recorded that the shares of the appellant is admitted. Therefore, some clarification from the learned counsel, Mr. A.R. Bhunyal, and senior counsel assisted by Mr.
And that's so.
N.
That's so.
And Z, so the, my lord.
Learned counsel is required. Just according to the learned, on the prayer made by learned senior counsel for the petition, list on 18. 5/2026.
My lord. Obliged.
For admission, item 17.
Where is the plain?
My lord, page 16. Prayer started 26. Yes, and the lordship will find the application under order 39, rule 1 and 2, at page 31. On the prayer, interim prayer at page 41. Is not to alienate, disturb ownership, right and peaceful possession of the petitioners over the Schedule A premises. And further, on being heard of the matter, the prayer made is going to be absolute. This is the interim prayer and restrain from disturbing the ownership and possessory rights. And the trial court passed the order, page 44. Since it was for a specific performance of a purported agreement of 2003, and the suit was filed in 2023. So it has been recorded that from the present stage of the suit is
my lord, I'm told that in the injunction application is in abeyance. That's what I'm told. Because of
What happens to the suit?
it probably paid, my lord. I think should,
No, you see, my query is limited for the different purpose.
my lord.
See, after an order of injunction, thereafter the first appellate court passes an order of an injunction on 7/10/2023. So 24, 25, 26. 3 years is quite a long time for this to be pending. That means nobody is interested in suit.
Yes.
All interested in
In fact,
injunction.
I propose that Lordship may remand the matter with a direction to the trial court to dispose of that, because we have filed the objection in the order 39(1) and 2, and that is pending before the trial court. And
No, that miscase is disposed of already.
no,
The first appellate court has dismissed the, has passed an order completely.
yes, the first appellate court has, it's pending for plaintiff's evidence, that main suit.
No, but that suit we have not stayed.
No, suit has not been stayed.
There is no question
As
of.
far as the injunction application, that is still pending. Because we got the stay
How
order
can that
from.
be? See, look at the first appellate order,
Yes,
7/10/2023. Which page is that?
710 is, my lord, 75,
75.
75.
Come to page 18.
Yes,
So you see what is being passed by the first appellate court.
Yes.
In view of the discussion above, it is crystal clear that the cardinal principle of injunction is satisfied in favor of the petitioners. Hence, it is a fit case for exercising power conferred under Order 59, Rule 1 and 2 CPC. In exercising the power conferred under Order 59, Rule 1 and 2 of CPC, OP men agents representing are restrained from entering into the suit and disposal of.
till
Yes.
disposal of that.
So this is final.
That makes the original application under order 31.
It's not just because the first appellate order.
My lord, but this is what has been challenged before this honorable court. The learned first appellate court could not have passed this order because of the fact that in the there was a delay of 10 years.
You see, ultimately, even if this is set aside, sent back,
Yes.
you have contracted with the, what do you call, your predecessor contracted with the plaintiffs for that land. They were put into possession. Rightly or wrongly, that's their claim. Even without this order of injunction, can you still go into that land? Let us say there is no order of injunction, no application for injunction.
I am there. As on date, I am occupying the possession is with me. But this order will restrain the defendant from entering into the.
But you couldn't have been in possession.
Yes, my lord, that is the case. We have stated in our objection, you will find our objection at 62. The written statement. We have disputed the possession as well as
See,
agreement.
the land is 45. Or you, let us say come to your cost title,
Yes,
come to your cost title. Your address is at Ulubari
yes,
and the address of the respondents. Ulubari Patanja.
yes.
So
The address of the plaintiff is at Cotton Bazar. The suit property as well as the plaintiff defendant's address is the study basti, that is Ulubari. That is under my possession. I am the defendant.
appellant hearing. The first trial court person asked to issue notice because there was a delay of more than 10 years for approaching the court for a specific performance of the alleged contract and for sale deed. Kindly see the prayer, Lordship will find the prayer, my lord, prayer in the plain, page 26. And page 27, they say degree of confirmation. Yes. We are asking that question. And Roman 4, they are saying a degree of declaration that the plaintiff being legal heirs that are entitled to seek specific performance of the contract of the sale deed dated 2/6/2003. Now, you see, limitation is a which question of that sale deed itself is it's not an unregistered sale deed. That is why we are before this honorable court. Without going through those documents, without going through our objection, the learned first appellate court has passed an injunction order, ad interim injunction, till disposal of the suit, and that was not the prayer of the plaintiffs also. The prayer of the plaintiffs in the first appeal, along with the injunction application, that is also not there. Kindly see the memo of appeal, page 45, and the order 39 rule 1-2, along with the memo of appeal, page 53. You see, where maybe the plain makes sense, because in 4 you are referring to page 4 as a prayer 4. But again in para 7 of the prayer, oh sorry, 8 of the prayer, they are asking for a registration of a sale deed. Therefore, yes, it's their case that they have been given the position.
Lordship, may kindly see page 66, madam.
This is something I dislike. Prayer of page 56. When I am putting questions to the counsel for the appellant, please restrain yourself.
Pardon.
This is something which I would violently react to.
Pardon.
Please sit down. You see, the first golden principle of the code of ethics for a lawyer is that he should respect the other side. If you don't know that much, then you are not a full-fledged counsel to be respected. So we also retaliate in the same manner, which will disturb you.
Pardon.
Don't do it. In the courtroom, please maintain that decorum. You don't know to show respect to the other side. Do you expect the court to show respect to you? Don't do it. Please sit down. Yes, Mr. Lord. Page 56, the prayer in the miscellaneous appeal and the miscase filed in the miscellaneous appeal, page 56. I don't know, you see, I get jumbled up because I read very casually and then I jump to conclusions. This is filed in the just a moment. This appeal is filed by the appellant. Correct. Miss Appeal 10 was by you. By plaintiff, not by the defendant. By plaintiffs. Right. By plaintiffs. Against the order? Yes. Page 47. Come to page 47. Yes. It's a part of that appeal. Yes. Last line of paragraph 6. Further, the respondent has also alleged. Respondent is you. I am the respondent. Respondent has also alleged that the appellants are forcefully in possession of the suit free land. That is in response to the legal notice. It talks about legal notice. This makes an admission that you were not the owners of the.
in occupation of the land.
I am in occupation of the land. May I just read the entire paragraph? After inquiry, the appellants came to know that respondent has never applied for any sale permission in order to execute the registered sale deed in favor of the appellants. Accordingly, the appellants, having no option left, issued a legal notice dated 5/1/2023 to the respondent for executing the registered sale deed for the Schedule A land in favor of the present appellants. After receiving the above mentioned legal notice, the respondent also issued a reply dated 9/2/2020.
You are the respondent.
I am the respondent.
You gave a reply.
I gave a reply against the said notice. However, to the utter dismay to the appellants, the respondent outright denied the execution of any agreement in favor of the predecessor of the appellants. Further, the respondent had also alleged that the appellants are forcefully in possession of the Schedule A land. In the said reply dated 9/2/2023, the respondent also stated the appellants are not entitled to get any sale deed in their favor, and the respondent is not responsible to perform his part of contract. As such, on 9/2/2023, the respondent has clearly specified, denied, and refused to perform his part of the aforementioned contract.
When the notice was issued, your first response by advocate's reply was that the appellants are in possession.
No, my lord, that has been denied. I have filed my written objection.
Look at this.
It is the version of the appellant. Because
But those documents are not here.
yes, but the trial court, the first appellate court has not given us an opportunity to file an opportunity to file a written objection even.
No,
No opportunity.
it was refused, it came in appeal, and in appeal, the appellate order was passed.
Appellate order was passed. Although it has been reflected that we refuse to file any objection. Why should we have filed our written objection in
We
the
have made a prima facie case. Yes, now you tell us.
Please, Your Lordship. What should may kindly see page 63 of the
63.
63.
Yes, 63.
to para 9 para 5 Counting the Mayor is Lordship. Counting the submission, learned counsel for the respondent has submitted that there was an agreement dated 12/6/2003 between the respondent and the predecessor of the appellant for sale of the land, and in the said agreement there was a clear stipulation that the rental value would be executed within 6 months after obtaining the sale permission. The sale permission, my lord, was to be obtained by the petitioner, my lord, as per the agreement for sale.
Once you read this, then the suit is liable to be dismissed on the ground of limitation alone. 2003 agreement you have come for enforcement now.
Well, subsequent page 66, my lord.
If that is there, then there is no prima facie case. How will the injunction be issued then?
Page 66. my lord.
I'm on principles of injunction, not on your suit. If it's an agreement for sale of 12/6/2003,
Right.
you see, when Mr. Dhar argued, we omitted that. We did not listen to him when he said about 12/3/2003. He referred to it twice, but we omitted that in view of the issue of injunction. Now, as the plaintiffs, you stand up and say that it was an agreement of 12/6/2003, then tell us, well, how you maintain the suit, how do you overcome the limitation?
Because, my lord, in the agreement, my lord, there was a clause, my lord, where it was stated that the petitioner will obtain the sale permission.
Does it extend limitation? Is not, then your prima facie case for injunction is not there.
Further, my lord, it is an admitted position, my lord, that I am in possession of the land. Page 66, my lord, para 11, my lord. They have admitted before the appellate court, my lord. that-
That's why at certain times you don't hear things. You highlighted that and we have to now hear you. 12/6/2003, whether you are in possession or not, can interfere with and you go back. Matter has to be remanded if the opportunity to file a written objection is not there. It goes back.
Further, my lord, what the conduct, my lord, what they have done, my lord, during the pendency of the injunction order, my lord, they have forcefully dispossessed me. Those materials have also been not mentioned in the revision petition.
You're not in possession.
Those materials have been concealed, my lord. I have filed 2 miscases, my lord. And
That is more damaging to you than helps to you. Mr. Dhar has rightly argued that he is in possession and therefore he can't be, by way of an injunction, he can't be ousted. To perfect his case.
but my lord, during
We
the
are not inclined
pendency,
to listen.
but during the pendency of an injunction order, my lord, they have forcefully dispossessed me.
That's okay, rightly or wrongly, he's in possession now. So by an injunction, he can't be disturbed. You damage your case totally.
But if my lord, if I'm being allowed to be dispossessed during the pendency of an
But that
injunction
there are
order,
other remedies, we are not there to hear that. In 227, sorry, the appeal under 115, we are not there to hear that. First you have to go to the trial court, then appellate court, then come here, then we listen to you. Little bit. Now you see how damaging it is to distract us. We were against Mr. Thorpe. We were justifying that the order would be appropriate. Now you have made 2 submissions and they have destroyed your case. Heard Mr. Thorpe Leonard for the petitioner. Also heard Mr.
Amale.
and the respondents. There are only 2 respondents? Yes, sir. How many respondents there? Only 2. Filing this revision under section 115 of the CPC. So this is under 227. How?
Also read with 115.
No. 2 things can't do together. If it is certiorari, then you stand to explain it to us how it is perverse. If it is 115, we have strike it out 227. The application is filed both under Article 227 and Section 115 of the CPC on the prayer made by unconstitutional of the provision of challenge under Article 227 of the Constitution of India, which is cut off. Accordingly, this revision shall be considered on the 1 under Section 115 of the CPC. Next, by this revision, the petitioner has assailed the order dated 7/10/2023 passed by the learned Additional District Judge number 1, Kamrup Metro, Gauhati, in NIS J case number 49 of 2023, arising out of NIS appeal number 10 of 2023. So by the said order, the application filed by the respondents under Order 39, Rules 1 and 2, CPC was allowed, permanently restraining the petitioner from entering into the suit land till the disposal of title suit number 208 of 2023. Next. the respondents had filed a suit for declaration and consequential release seeking part performance of an oral agreement for sale dated 10/5/2003 entered by the appellant with Prashanta Kumar Datta, PRASANK, Prashanta Kumar Datta, the predecessor in interest of the respondents in respect of land described in Schedule A of the plaint, projecting that the said agreement is valid and enforceable. The petitioner, the respondents, the plaintiffs had also sought for decree of specific performance of contract executing a sale deed in favor of the respondents, that's plaintiffs, from a degree of confirmation that they are in valid and legal possession of the Schedule A land and for permanent injunction against the appellants, when against not to disturb the peaceful position and day-to-day activities of the respondents as plaintiff respect of Schedule A property. The learned civil judge number 1 from Kamrup Metro from Gauhati on an application filed under Order 59 Rule 1 and 2 CPC seeking ad interim injunction issued notice by order dated 10/4/2023. No, where is the trial court order? 44, page 44. Okay, 40, please. Trial order dated 10/4/2023. Notice agreed by only issuance of a notice without any order of any injunction from the respondents that plaintiffs filed an appeal under Order 43 Rule 1 within bracket R of the CPC was registered as Miss Appeal number 10 of 2023. Along with this said memo of PV, the respondents that plaintiffs had also filed a separate application under Order 59 Rules 1 and 2 of the CPC for an ad interim injunction. The learned additional district judge number 1 from Kamrup Metro, Gauhati, by its judgment order dated 7/10/2023, allowed the appeal and for reasons assigned in said order, Examining the three principles of grant of ad interim injunction. And arrive at the conclusion that if the injunction was not granted from the respondents that plaintiff would suffer irreparable loss and injury. And accordingly, ad interim injunction and accordingly allowed the appeal on contest without cost. Setting aside the order dated 10/4/2023 passed by the learned civil judge number 2 for Kamruk Metro at Gauhati in Ministry case number 361 of 2023.
Where is the order? Page 75, Mala. There are two, one is judgment and the other is in past order in the miss case.
Oh. The appeal. The order.
And the relevant
Separate order.
separate order.
It is 7/10/2023 passed by the said learned court in Ministry case number 49 of 2023. Please to pass an ad interim injunction under order 39 rule 1 and 2 by restraining the appellant, defendant from entering into the suit land till disposal of statute number 208 of 2023. Next, let's go dispute at the bar that the proceedings of BJ case number 361 of 2023 was not disposed of. And the learned counsel for the appellant has submitted that the said proceeding is still pending for disposal before the court of learned civil judge within bracket senior division, case number 2, Kamruk Metro, Gauhati. And though no opportunity to be granted to the, was granted to the appellant for filing objection to the said injunction application. In the meantime, the appellate
Petitioner. Where the petitioner here?
petitioner. And the petitioner, on receipt of notice in connection with the Appeal number 10 of 2023, participated in the said proceedings and no opportunity be availed for filing any written objection to the injunction application being this J case number 361 of 2023. Next, when the learned counsel for the court side put forth their submissions, project that they are in project that their respective parties are in position. My in course of submissions, the learned counsel for the respondent has submitted that during the pendency of that this appeal number 10 of 2023, comma, the petitioner that defendants, petitioner that dispossessed the respondent plaintiff from the suit land. So in the considered opinion report, comma, considered counsel for the petitioner and for the respondent that plaintiff, which plaintiff submission, they are not in collusion. And they have been outfit by the allegedly outfit by the petitioners that defendants are illegal. Because during dependency of Miss Appeal number 10 of 2023, the appeal order restraining the petitioners that defendant from entering into the suit plan being passed on the premises that the respondent that plaintiff were in possession not be sustained. Moreover, there is another reason for interfering with the interim order. The unsuspected court, without allowing the petitioners that defendants the opportunity to contest the proceedings of media case number 361 of 2023 by granting granting temporary injunction till the disposal of PS number 208 of 2023 has practically non-suited the that defendants from set proceedings of media case number 361 of 2023. So for the stand from original findings against the case number 361 of 2023 of the petitioner that defendants was never allowed to be brought on record. But therefore, the order of injunction was passed without any opportunity for the petitioner and defendants to rebut the allegations made in of the stand taken by the respondent that plaintiff in this case, media case number 361 of 2023, which is the entire therefore, the appellate order dated 7/10/2023 passed by the additional district judge number 1, Metro Gauhati in media case number 49 of 2023, arising at Miss Appeal number 10 of 2023. Will not be found sustainable for hereby interpret with and certified. The matter arising out of media case number 361 of 2023. Pending before the court of civil judge, senior division, number 2, shall remain on board of the said has to be got to its logical conclusion. the province, the revision stand, last extent is indicated above. Next one. The non civil judge, within bracket senior division, practical. Number two, Tampa Metro from a party, requested to petition to be here and dispose of proceedings of which case number 361 of the peak. As early as possible. By curtailing necessary adjournments, pay for adjournment made by either side. Next part. What is the date of appearance before the civil judge number 2?
25 of June, 2026.
25 June. Next part is the time. It is submitted before this court that the next date of proceedings before the direct civil judge senior division. Number 2, what is fixed on
25th of June.
25th of June. He is appropriate to, because the said landed court to prepone the proceedings to an early date, taking into account the matters already fixed on board. Next slide. The direct both sides were to be represented by the counsel to appear before the learned civil judge, the bracket senior division, bracket number 2, Gauhati, on 28/5/2026, and by producing a separate copy of the order, await for further orders to be passed by the state council. Next one. As both sides allege to be in possession of the input land, the change of land by the learned counsel to be responded as the respondent attended the discovery. Both sides were abstained from disturbing the status quo with respect of the land. Till the next appearance before the learned counsel, i.e. as on till 28/5/2026.
But the only thing, the trial court shall not be influenced by the any observations passed in the judgment, and
We're not given any observations. What did I say?
so that judgment, trial court, first appellate court judgment. Miss
That has been set aside.
Right.
If the honorable judge is, what do you call the, learned magistrate influence, you have another round to come. We don't know because, slowly and slowly we are getting outdated. If the new thinking is that, even order set aside will be influencing something,
So that sometimes,
we have to change ourselves now.
sometimes the trial court gets influenced.
So we don't know. That's why we said we are being outdated slowly and slowly. I've kept a white beard and, many, council appearing before me told us that, no, shave it off. I wanted to look old. I keep myself a feeling that I am being outdated. No. Obliged, just in a writer note picture as well. And not too monotonous, let's say. Okay.
Obliged.
Item 18.
The extent is negative. Yes,
But this is
regarding granting of injunction by the appellate court, my lord. Against that, I preferred this revision. The injunction was granted by the lower appellate court, my lord. Initially, the injunction was refused. I am the defendant. And then appellate court reversed it and allowed the injunction.
Where is your plaint?
Yes, plaint at page 11.
May I please, but I have objection regarding maintainability of the petition.
Objection.
But
Then you have the right to make first submission. Yes, please proceed.
Lordship, may peruse, page 1 of the petition, Your Honor.
Page 1.
Lordship, perfect.
Yes.
In the matter of an application under section 115, 151 of the CPC, read with article 2 to 7 of the Constitution of India.
Yes.
Lordship, this honorable court already held that parallelly under article 227 cannot invoke parallelly under article 226, 27 and 115 of CPC, Your Honor. In this regard, I am relying a citation of this honorable court, Your Honor.
You see, in the last case, you were there, you were hearing the dictation in the last case. In the last matter, we were dictating the order. Have you heard it? No. That's the difficulty. In the last order, we also already took care of that. We know of this and we took care of that.
227.
There are 5.
Para?
5.
But this court did not dismiss the matter on that ground. Ultimately, it was adjudicated. Correct. There is also order authored by me in this regard. Many orders where 225, 227 and 115 would not stand together. That is why in my last order, I said that we strike it out. It is always the power of the court to do that. And you can't restrain the power of the court to strike out that part of pleadings which, according to us, is unnecessary. This goes. Again, merit. Yes, Mr. Ghosh.
My lord, I am saying that under Article 227, it may be considered. Under Article 227.
You want this to be heard under Article 227?
220, because 115 is not, may not be maintainable. Because the appellate decision order 39 rule 1 and 2 petition was rejected. Then they preferred, that is the plaintiff preferred appeal, and by the appellate court, the injunction was granted. Against that, we have approached before this honorable court.
Yes.
My lord, kindly see the plaint, my lord.
You've seen the plaint, there's a request prepared for addendum injunction, permanent injunction.
And not only that, the suit is for declaration of tenancy right of the plaintiff over the suit land, for confirmation of possession of the plaintiff over the suit land. This is the prayer. And this was objected by the present petitioner by filing objection stating that we are in possession over the suit land, and we are, the fishery is running over this woodland, and that too, this fishery was, government fishery.
If I have, if I remember vividly, sorry, roughly if I remember it, in this case, there are fisheries,
Fisheries,
correct?
yes.
And there's a plea of tenancy.
By them.
There's a plea of tenancy
Plea
by
of
them.
tenancy.
Yes.
My lord, to that aspect, my lord, regarding plea of tenancy, I have brought by way of additional evidence, my lord, additional affidavit, my lord. Kindly see page 67 of my additional.
But somewhere in this,
This was
somewhere in this bunch of papers, there is a reference to Khatian being granted to the respondent.
that is why in the additional affidavit, I am showing, my lord, the document which we have produced, my lord. Page 67, running page. Lordship got it. Page 67.
Yes.
To the Deputy Commissioner Hailagandhi, prayer for cancellation of sealing certificate filed dated so and so issued by in the name of Abdul Qasim Laskar. That is, Abdul Qasim Laskar is the son of the present defendant. That is present petitioner. With due respect, state that we have been possessing the schedule so and so since time of our father so and so in respect of the scheduled land. A tenancy Khatian was issued in our father name of so and so of so and so so and so.
What is the name? Father?
Ramcharit Gwala.
Ramcharit Gwala.
Gwala.
Yes.
That sir, the scheduled land is low-lying land, and we are earlier used to enjoy by cultivating so and so variety of paddy. But for last few years, we dug a fishery and enjoying the same as a fishery. That sir, one Ayub Ali Laskar disposes us from the said fishery land and showing false document obtained from fishery loan, and now it has been learned that in collusion of the lot Patwari so and so now retired caused a false survey of the land and obtained above mentioned sealing certificate without field verification concern our land of the above mentioned tenancy Khatian. So Khatian be prayer. Then next page. Then notice was issued by the Deputy Commissioner to all the parties, my lord. Next page. Then it was adjudicated, page 70. Seen and peruse the complaint so and so filed by Nirmal Gwala. Lordship got it. So and so. Also seen peruse the inquiry report furnished by Assistant Settlement Officer Hailagandhi so and so. It reveals from the above report that land measuring 6 biga 13 kata covering so and so of Moja so and so has not been found under possession nor recorded in the name of Nirmal Gwala. Son of late Ram Charitra Gwala. It is also mentioned in the report that quantum of land measuring so and so Moja has been allotted in the name of Abdul Qasim Laskar in favor of my son, over which I am running the fishery. And in respect to this fishery, my lord, government also sanctioned that next page. Construction of fishery hatchery under PM so and so so and so. And I have been running this fishery over this plot of land on the basis of this loan sanctioned by the government. And this part has been considered by the learned trial court. That they are not in possession, we are in possession, and injunction was rejected. Kindly see the order passed by the learned trial court, my lord, page 38. Page 38.
But Mr. Combs have made then self-defining submission when we refer to this provision of 115 and 227. You elected for 227. In 227, we can't touch the order of the first appellate court unless there is a perversity shown.
That I will show.
And second is that if in respect of orders of injunction, a revision lies under 115, then and if you if an order of injunction was passed, this order of injunction was passed by the appellate court in appeal.
In appeal.
So what is the remedy then? 115.
227.
227 can't be applied. My lord, only under 43 rule 1 and 2 disposes of the
This is an
appeal under order 43 rule 1R.
Yes. This order has been passed under order 43 rule 1R.
Under 1R, then only remedy is 115. The 227 is not an appropriate remedy.
That part I will check, my lord.
It's just not maintainable. You like that.
Then, my lord, may I pray that
227 would be an order without jurisdiction. The first appellate court had the power of adjudication. Passed an order. Mr. Sharma, take your guidance here. Against the first appellate order in injunction, order 41 rule 1R. I think revision would lie. It can be challenged in appeal. 227. No. It will be revisional order.
Against the appellate court's order. The second appeal against the order.
No, if that is passed in exercise of original jurisdiction, if in a appeal an injunction is granted, then second appeal against order. Just check up.
I'll check up. But so far, my knowledge is concerned, my lord, 227 is the appropriate remedy, my lord. Because otherwise, it has not attained finality order which has been passed in the injunction.
No, this disposes of the first appeal. It can't be said to be pending. So order can't be revised down to 227. That's the idea I'm having. But nevertheless, we address also on that. Sunday. Yes, Monday to petition. Monday to petition. Correct. Huh? Petition. Goes to 20.
20, 21, 21.
21 is Thursday. We have many matters fixed which are old appeals on these dates. That's why. We have pendency of first appeal from 2011. Those we are taking into prior. Both sides are represented. This appeal, that is this application. Okay. They are applying the provisions of section 115 CPC as well as article 227 of the Constitution of India. As the Indian order disposes of this appeal number 14 of 2023. Both sides will address the court whether the order can be assailed either under section 115 or under Article 27 of the Constitution of India, or the second appeal against orders of fact.
The second appeal is not.
It's okay, Mr. Sharma, again, we have, let us settle the law. Accordingly, it's the matter of 205226.
Obliged.
We have requested Mr. Sharma to give his advice. We have taken his advice, and therefore it has to be part of the order. Must. Whether it will lie or not, that will satisfy.
Item 19.
May I please, Your Lordship?
The government, you are there? The government? You have got the record?
Copy of that 407 proceedings.
10.
Sorry, 102.
107, 144 proceedings.
Lord. What I take my.
This is 107.
This proceeding is installed. This proceeding has been installed in the before the executive magistrate office.
That would lose its efficacy by now. This was the case of 2015.
Yes,
Lord,
Lord.
efficacy by now. Thank you. Where is the order of the special tribunal?
Well,
Where is the order of the special tribunal?
Yes, Indian order, madam. Page 41, madam.
You are the complainant or the accused?
Well, I am the accused, madam.
Now, whether the respondent has been put into possession? No.
In
Respondent has not been put into possession.
In fact, my lord, respondent, my lord, as per the my lord reports, my lord, no one is in a position. And I have been, my lord, held to be liable for, my lord, to be prosecuted under, my lord, section 4. And, my lord, I have been directed to pay compensation of rupees 1 lakh for, my lord, illegal possession for 7 years, my lord. I'm disputing that, my lord, because my case is that, my lord, in fact, there is no cases made out that, in fact, I had taken over possession or was even trying to take over possession. And reports were called from the revenue to cycle officer, my lord. And that report said, my lord, that no one is in possession. In fact, both of them, my lord, are brothers, my lord. Complainant and the respondent.
What does this observation in page 45 mean? Come to page 45,
45.
paragraph 8. PW1 during cross-examination it reports that the respondent is his elder brother with whom he has got a case under section 107 of the 145 and he has applied for Jamamandi before the SDC but he has not sent any notice of relation to the respondent. He has filed this case and has obtained a report from the court. As per the report, Suitland is not in possession of any of them.
Any of them.
Now, where is that report?
Well, that report I have not annexed, but there's a part of the record. Lordship will see at page 51 also, para 23.
So this position, who has given the, which court has given that declaration that who is in position or who is not in position?
Well, it's a, here, I mean, it says court, my lord, then para 51, it says the report from circle officer, my lord.
In which proceedings that has arisen? The report has come on record.
Yes, my lord.
In which proceedings?
Well, that, of course, my lord, it's not a part of this record. At least I have not filed, my lord, anything like that sort, my lord. I was not having that copy. But, my lord,
This question has a relevance. Because of this, Mr. Sharma, you will have to respond to it. You see, this land grabbing case is numbered as 45 of 2016. And in this case, 99 of 15, which is the 107 proceeding, is of the year 2015. Now, this report referred to is, as per page 51, is a report dated 2/8/2017.
17.
So therefore, we are asking this report arose out of which proceedings?
Lord, the PW, my lord, PW1, my lord, in his evidence, my lord, he had exhibited, my lord,
that this report is not a part of the exhibit. Page 28, my lord, is evidence, my lord, is PW1. It exhibited the gift deeds, then, my lord, certified copy of Jamabandi land holding certificate and a land revenue paying receipt. Now, this report nowhere finds mention, my lord, in the exhibits, my lord, produced by the PW1, my lord. But it's only the cross-examination when this report is referred to. And my lord, the cross-examination took place in 2018, my lord. So perhaps this is the same report, my lord. Maybe it was called for by the learned tribunal, my lord. That is it was as it appears, my lord. Otherwise, there's nothing specific how this report came into, my lord, being.
So Sharma, it's not right. Who is in possession of the land now? Who is in possession of the land now?
Exhibition case is pending.
Hmm?
Exhibition case is pending.
You are not in possession.
I am not.
In fact, my lord, the original respondent
So, Rajiv, can we see the order dated 22/5/2024? As in this case. Here, my lord,
20?
22/5/2024.
22,
Last page. However, this court makes it clear that the improved order that the so and so is here, the direction that the respondent herein shall be put in position of visible land is not state.
In fact, the original respondent expired in he had already sold the land to his daughter, who is now contesting, sold the land, and he is contesting this case.
Yes, Mr. Prita.
But no, my lord, my basic contention is, my lord, that the findings that, my lord, I had dispossessed, or that I was even trying to dispossess, my lord. What happened, my lord, the petitioner, the complainant, he claimed, my lord, that he got this land by a gift deed. And the petitioner before your lordship, my lord, our contention was that, my lord, my father had partitioned the property, or my lord,
See, you have to tell me specific terms as to whether if you are not dispossessed, you have to tell that.
my lord.
If you are dispossessed, you have to tell that.
Yes, my lord.
According to you, we understand that you have not dispossessed.
Not dispossessed.
If it is not dispossessed, then we direct the respondents to hand it over by whoever is in possession. The district administration will send at least one battalion of their armed police constables and get them in possession.
Well, I have not said that I am in possession or I am trying to get the position. That's my stand, my lord, because I am basically saying that, my lord, this entire, my lord, finding with regard to, my lord, disposition and, my lord, alleged even attempt, because, my lord, the plaintiff number one, my lord, in his cross-examination has admitted that, my lord, there was no, my lord, so-called threat on 27/2016. He was relying upon a case, my lord, that's why this record was called for. My lord, his initial case was that in 2015, because of the disturbances, he filed this 107 proceedings. And the moment this proceeding was stopped, I started disturbing him again. But the next day he filed the case. He says that the case was stopped on 27. On that day, from that day onwards, I started disturbing him again. And he filed this case on 21/7. The next day he files the case. Lordship will see his averments. Para 5, my lord. Page 18. Page 18, my lord. Para 5. May I read now? Yes. The aforementioned respondents accuse persons who have got no valid land documents as ownership and title or lawful possessor in respect of suit land, but they, out of greed, form a group of persons try to grab the suit land, including the lands of the complainant illegally by using force in the middle part of May 2015. But due to timely intervention by the case filed with the complainant under section 107, 144, 145 CRPC before the Court of Executive Magistrate Gwalpara, being the case number 19/15, they could neither enter the suit land nor could succeed in threatening as the said case was ended when the complainant continued to possess the land till 27/2016 peacefully. However, the respondent accused persons above named were again on and from 27/2016 trying to dispose of the complainant from the said land in question by causing unlawful threatening with dire consequences on the strength of their muscle power and trying to plow the suit land by tractor, and also adamant not to stop their illegal or forceful threatening towards the complainant with a view to occupy the suit land illegally at any moment of time, apprehending and preventing him not to plow and cultivate the suit land in the ongoing Sali crop season, which resulted in irreparable loss and substantial damage to the complainant. Moreover, now they are advertising themselves that they are supposing the original owners of the suit land, and thus they are trying to grab it, despite the face of repeated requests made by the complainant and along with his witness, but in vain. Besides, they are also searching probable purchasers to sell out the suit land by evicting the complainant from the personal wrongful gain, taking the advantage of weakness of the complainant. In doing so, the respondent accused are going to commit the offense under relevant provisions of the Assam Land Grabbing Prohibition Act 2010 as land grabbers of the suit land, which is required to protect and restore immediately as per the provisions of law enforced in the interest of justice. That the cause of action for the complainant arose on and from 27/2016 when the accused persons are jointly, collectively showing dire consequences towards the complainant with a view to grab the suit land and every subsequent dates at Hadigaon under the Agia police station within the jurisdiction of Gwalpara district. Now, this case was filed on the next day itself. You will see the filing date 21/7/2016. So he says that I have been disturbing him from 27/2016. He files the case on the next day. So therefore, my lord, this entire story of my lord, it's totally, my lord, concocted, my lord. Then, my lord, in his cross-examination, my lord, he says, my lord, that it is not a fact that on 27/16, the respondent along with his men came and threatened and dispossessed me, my lord. The vernacular version is that, my lord, page 30.
31, my lord.
31.
Yes, my lord. The vernacular version is page 31, my lord. Last paragraph, my lord, page 31. He says that there was no threat as such.
It's also PW1.
PW1, my lord. He is the claim. He was the complainant, my lord. PW2,
Just the song.
my lord.
Page 31, you are saying
Last line, last paragraph, my lord. 20/7/2000
Okay.
16 তাৰিখৰ 16 তাৰিখে
বিবাদীয়
বিবাদীয়
লগত
মানুহ লৈ আহি মোৰ বেদখল কৰা আৰু কি
গোচৰৰ বাবে ভাবুকি দিয়ে আৰু
কথা সত্য নহয় so he denied. Now PW2, my lord, in his cross examination says that it is not a fact that Abad is in possession of the land. Page 33, my lord. I have the translated version, my lord. He is the last but third paragraph. It is not a fact that Abad is in possession of the land. Hence, he did not take possession of the land. I have come to depose in favor of my father-in-law. I am a Mohori of the Gwalpara court.
Correct. It is not a fact that Abad is in possession of the land, hence he did not take possession of the land. So you are suggesting in the cross-examination that X has the land and therefore he has not taken it.
Well,
that can't be read to mean that he is not.
But then he has not said that, my lord. That, my lord, I had tried to dispose it because his version is that, my lord. And, my lord, so far the PW3 is concerned, my lord, page, my lord, 37, he says that I have not seen the respondent Abad Ali illegally occupy the disputed land.
You have reading there.
Page 37, my lord. The PW3, my lord. He is the witness to the deed. I have not seen the respondent Abad Ali illegally occupy the disputed land. I do not know who is in possession there. Then he says, I have not read the evidence in affidavit, only I signed it. So he signed whatever is given to him to sign. But then there he says, page 35, it's a hearsay. Page 35, my lord, his assertions on, my lord, the so-called, my lord, possession or, my lord, grabbing of land, my lord. Page 35, para 5. I have heard that the respondents in several times tried to grab the suit land by using force but failed. So this is the hearsay evidence. PW2, my lord. Sorry, that was PW, my lord, 2. He said he heard. That PW3 also says the same thing. Page 39, para 6. Para 6, my lord, page 39, PW3. I heard from the complainant that the respondents in several times tried to grab the suit land illegally by using force but failed. Now the PW1, my lord, in his cross-examination with the complainant, he denies, my lord, that on 27/2016, which is the basis of this case, my lord, he says that there was no threat to me. In cross-examination, like that, my lord. And, my lord, I've been, my lord, given a, my lord, I've been made to penal, my lord, I've been given a penalty of 1 lakh, my lord, as compensation for, my lord, illegal possession of 7 years, which I never had, my lord.
That's all.
And, my lord, that for prosecution, my lord, for under, my lord,
offense, section 4, my lord. And moreover, my lord, so far as the compensation is concerned, compensation is basically with regard to possession, illegal possession. It's not an attempt of, because even attempt is also, my lord, a land grabbing act. So therefore, my lord, the possession, if the compensation is only for illegal possession. So that could not have been settled on me.
Yes, Mr. Sharma.
May I please? Well, the people subsequently turn to page 24. That is their 18th statement. Paragraph number 8. That shall the allegations of grabbing the disputed land by the respondent side does not arise as the said land is question under the continuous
Paragraph of page.
paragraph number 8.
Paragraph 8.
Paragraph.
Yes.
As well as the evidence in chief of the PW1 at page 30, paragraph number 10.
Page 13, paragraph 10.
Paragraph 10, page 30. Now I say that the respondent are still
30.
30.
Yes.
I said the respondents are still putting unlawful threatening and trying to grab the aforesaid land to me and to me, due to which I afraid of entering into this land for cultivation and now which is now lying vacant, and as such the aforesaid illegal act of the respondent I have suffered substantial loss. But it is a cultivable land. Therefore, it is a possession by cultivation. Therefore, it may be they are trying to cultivate the land, and as they are trying to cultivate the land, and they themselves stated that they are in continuous possession of the land. Therefore, the case has been made out under the land grabbing act. They are trying to grab the land. Physical possession is not at all necessary. It is a possession by cultivation. And we also prove our title by exhibiting the gift deed and other things. And when the defendant said has not produced any evidence. Defendant said has not produced any evidence. They are not cross-examined that.
So there is no dispute that, even you don't dispute that, Mr. Desai is not in the land.
No, sir.
But then how can the order be passed if he is not in the land? How can it be said that he is, grabbed the land and he is to be
Trying
disposed?
to grab the land.
So, but the order is to put you into possession.
Yes.
How can that order be passed? That order would be per se illegal.
Mother, you also can see, there is a cultivable land. And we are not allowed to enter. Therefore, they are trying to grab this.
That's not the case. That's not the case, built up. You see, if you are in possession, you are being restrained. Can somebody say that you have been dispossessed and you possess? Can't you, that order can't stand. So therefore, the act of land grabbing has not happened.
The act of land grabbing is happened.
How?
Because they
How
themselves,
it is?
they themselves,
Mr. Tata has been able to demolish that. He says that your first complaint is that on 27/16, you alleged that there was an attempt to grab your land. On 21/7, you were already before the tribunal. One day of settling,
they are threatening from us from the month of May.
Mr. Tata has read that part in your petition. Your first complaint is that on 27, the first act of disturbance in possession was there. That is at page 27.
That's to denying proceedings.
Para 6.
That to denied in cross-examination, man.
That has not been designed. Designed will come later.
Now, you are also can turn to page 18, paragraph number 5. That the aforementioned respondent accused persons who have got no valid land document as ownership and the title of lawful possession, but they they out of grief,
I'm
claim
sorry,
they
I have
broke
to
of
write.
first.
I have to write this identity. Committee meeting. Continue to Thursday. Not a Thursday. Okay, that's the question that I didn't talk. But I think if I did partner this on. For others, Mr. Datta, you are.
In regards to item 62, can your lordship take it tomorrow?
Tomorrow it not be possible because we have fixed on Tuesdays and Thursdays many hearing matters.
No, I have seen that.
But you just check up and give it. It may not be to your satisfaction, but Potmas will give it.
Of like,
You can't accommodate everyone.
no, I cannot.
Few of request we can try to see. Okay, and for item number 25, you have to take care because I have a meeting right now. I want to go short. The government was there in the last matter. In the last matter, the government was there. So the government advocate was there.
Next week, next week, আমি থাকবো না next week.
The records of miscase number 99 of 2015.
এখানে বলছি আমি 25 তারিখে যে আমার ঈদ আছে জুনিয়র ফার্স্ট ইয়ার
In item 25, interim order is there, last.
খুব খারাপ Yes.